Yes.
May I please, Lord? But it doesn't matter. Item 5, my Lord. The purpose of the case already been fulfilled, my Lord. The circular officer by order dated 29/4/2022 already mutated.
So you will want to withdraw.
Personal.
It has become infractious.
Yes. Yes.
Mr. B. Rama, the counsel appearing on behalf of the petitioner submits that the matter has already become infractious inasmuch as the petitioner, and inasmuch as the land has already been mutated in favor of the petitioner, and as such has instructions not to press the instant writ petition. Accordingly, the petition stands closed on withdrawal.
Right.
Give your names.
Sure.
I don't put anybody's names now.
Made, please, Your Lord.
Yes.
So far as item number 12 is concerned, Your Lordship, today I have filed an affidavit in reply, Your Lordship.
Hmm.
So either Your Lordship may call for, or Your Lordship may take up this matter on Friday.
No, Friday. Let the matter come.
My-
Call for that.
I am giving.
Then,
Well, item number 100 of the participants, yesterday it was called.
oh yes, we'll take it up.
No, my lord, we have substantial relief we have got, my lord. The goods that were, my lord, penalized for due to overweight. My lord, after the interim order, my lord, we have reweighed it and it was within limit and the goods have been released.
So you want to withdraw?
Withdraw it.
Item number 100.
100.
The learned counsel appearing on behalf of the petitioner submits that pursuant to the interim order passed on
2010.
interim order passed on 2010-2014.
Right.
There has been already a re-weighment carried out. And as such, nothing survives in the instant writ petition. Accordingly, submits that the writ petition be submits that the petitioner does not want to press the instant writ petition.
Right.
The instant writ petition accordingly stands, the petition, the instant writ petition accordingly stands.
The liberty, my lord, to oppose if the
What?
situation
Every time is a separate cause of action.
Please, Lordship.
Yes,
Yes, Lordship, I beg to mention item number 58, sub-delete.
yes.
Lordship, the counsel for the petitioner is suffering viral fever. So,
Why did you go for by order then? 58 is by order.
Yes, Lord.
Why did you mention it?
Lordship, the counsel A. Kagoti is suffering from viral fever. Cannot take.
What about B. Agarwal? No, first of all, you have made it by order. And then you say that the council is not well. When did you make it by order?
Lordship, I do not have this knowledge because I have been informed by the petitioner counsel to mention.
The learned counsel appearing on behalf of the petitioner seeks for an accommodation. It reveals on record that the instant writ petition, it reveals from the cause list that the instant writ petition was listed on account of mentioning being made by the petitioner. The learned counsel appearing on behalf of the petitioner seeks for an accommodation. This is a matter of 6 weeks.
May I please, Lord? Lordship, I beg to mention item number 40 and 42, Lordship.
40?
And 42, my lord.
Yes, tell
My
me.
lord, in this case, my lord, instruction is awaited, my lord.
No. On time matters, no instructions are awaited. We need compliance. We'll look into it when the matter is called. It's a 2022 matter. Where is the question of instruction? Have you filed your affidavit or
No,
not?
my lord.
Then we will ask that person to be present.
My lord,
You have been given a right to file an affidavit. You have given the right of a counsel, taking into account that you are going to do after receiving the notice. You have not done so. So we will ask this person to be present tomorrow.
No, my lord. After.
No, tomorrow. The person has to be present.
No, my lord.
No. Who are these people? Anurag Goyal, yes, both. Let him be present
My
tomorrow.
lord, he is not the. My lord, he is already transferred, my lord.
We'll see when the matter is called.
My-
Don't ask for adjournment in contempt matter. Please, next.
Okay.
Yeah, I'm for the item 40, my lord. Yes, I am.
He is for a petitioner, my
I'm
lord.
for the petition.
You are giving allowing this adjournment. Don't, you want the
Let-
compliance?
No,
You
let-
want the
let-
compliance or not?
Let the matter reach better.
Yes.
Bless him.
What is your lordship? But you have declaration item number 4, my lord. My lord, we have circulated.
Madam, where is the contemner? You are appearing for Anurag Goel.
Fine.
What is he presently working as?
My lord, presently my lord do not.
Okay, ask him. We may ask him to have a video conference in the court and ask him why he has not complied,
Apply.
We'll take when the matter is,
My lord, I have declaration item number 4, my lord.
yes.
My lord, we have circulated the adjournment slip, my lord. We have to file a rejoinder, my lord. You
Who has
filing
to file a
it?
rejoinder?
Yes, my lord.
At the request of at the request of the petitioner, the matter stands adjourned for 6 weeks for filing so as to enable the petitioner to file a rejoinder to the affidavit in opposition so far.
Tell you later.
Item number 1,
Yes, why no steps?
Lordship, I've produced the office note, your lordship. It appears that on 27/6/2023, lordship, the matter was placed with the laws remark court, lordship. But unfortunately, lordship, we were not aware or we were not.
I'm not concerned. Why no steps?
So, lordship, I'll be taking steps upon respond number 6, 7, and 9 today itself. Lord.
We'll take it up at 2. Take your steps and come back. Take your steps by today and show me the receipt. Else I'm dismissing the petition for non-prosecution.
item number 2,
Yes,
In this case, Lordship, it is matter pertains to the Itanagar bench. It is first time this coming there, all the matters are transferred from there.
what are
So-
the matter pertains to?
Itanagar bench.
Understood. What?
Is
This is the land acquisition matter.
Yes,
Huh?
yes, land acquisition.
Okay, so you are appearing for the petitioner.
Yes, Lord.
Then what is there? Why you are not taking steps?
Lordship, we have served the copy for response number 2 and 1, 2 and 5. In register post, we have taken step in here,
Where?
here. Lordship.
When?
It is now they have send a copy to us. So Lordship may allow 3 days time. So in the meantime, we have.
You are going to take steps.
Yes, sir.
Your name
A Chetri Lordship, because I'm not in the record. I'm
and
not
naam to likh dijiye.
PD Nair.
Give your name.
Yes.
The counsel appearing on behalf of the petitioner submits that he will be taking the steps upon the response number 3 and 4 within 3 days. So list the matter on 26th of July. If no steps is taken within the period of 3 days from today.
In item number 54 with the same prayer.
Item number?
54. It is same, it is on Pengu Canal. 25, the requisition 2531.
Same.
Same, Lord.
Okay. Same order. 3 and 4.
3 and 4. Yes.
Same.
Obliged.
It will be listed on 26 if you don't take steps within these 3 days. I'm telling you.
Obliged.
Next.
item number 3 for admission.
Lordship, this matter will be taken up after some time, Lord.
Why?
Mr. Dinath will appear in this case. Mr. Dinath will appear, Lord.
We'll see. We don't require.
Otherwise, the claim has been admitted in an earlier round of litigation.
What is this matter about?
This is regarding handling in the public distribution system. Lordship knows that for handling of the food grain, there are certain commissions that is given. Now it's a 2-tier system here. First, the food grains are being brought in by the Gaon Panchayat Samavai Samiti, that is called the GPSS. And thereafter it is distributed by the fair price shop owner. Now, the particular commission that is to be provided for this particular handling is distributed in a ratio of 70:30. Now, 30% of that commission money is for the GPSS and 70 is for the fair price shop owners.
It
And in
appears,
earlier round
it
litigation-
appears from the records that there are as many as
35.
35 petitioners claiming their individual right for the transportation amount,
Commission amount.
commission amount. However, the court fee of only one petitioner has been paid. The learned counsel appearing on behalf of the petitioner submits that on or before the next date, you would have taken appropriate steps in the regard for payment of the deficit court fee. List the matter again on 26th of July 2020.
Obliged.
Item number 6,
Right, Mr. Lordship, the matter relating to victim compensation, my lord, but the DLSA has rejected the claim on the ground of delay, my lord, in pursuance of clause 7 of the notification 2012, my lord. My lord,
Where is the notification?
my lord, page 34, the impugn order.
Where is the notification?
Notification, my lord, page 20,
Clause 7 is where? Delay,
clause 7 at page 22, my lord.
the
No.
state, huh?
No claim made by the victim or his dependents under subsection 4 of section 357A of the Act shall be entertained.
Where, you are reading where?
My lord, page 22, my lord.
Yes, clause,
Clause 7, my lord.
clause 7 is the state or the district legal authority to alleviate the sufferings of a victim. But
Clause 7, limitation, my lord.
where? Or limitation, no
Limitation.
claim by the victim made by the victim or his dependents under subsection 4 of Human shall be entertained after a period of 6 months from the occurrence of the crime. Provided that the district so and so, if satisfied for the reasons to be recorded in writing, may condone the delay in filing the claim. Yes, then,
Yes. Then, my lord, come to section 357A4 of the CRPC, my lord.
yes, what does it say?
Section 4 said, my lord, where the offender is not raised.
CRPC conduction.
Here.
Give me the CRPC.
And we have also challenged this limitation part also. my lord.
When did you file your application?
My lord, application was filed in the year 2020,
11/11/20, Annexure 5.
after passing the judgment, my lord.
After passing the judgment.
Judgment.
The judgment was passed in 2017.
Yes, my lord,
Then why did you file it in 2020?
because my lord, it came to knowledge subsequently, my lord, that because my lord, the victim,
You are not a party.
because, yes, my lord, I am the father of the victim, my lord, but I was not the witness in the case, my lord.
Let me see 357.
357 for my lord.
Yes, an order under this section may also be made by the appellate or the so and so while exercising the power of revision. Depending on in any subsequent civil relation, even the court may take into account any sum paid or recovered as a compensation. Now, what does this court say anything?
No. Nothing said, my lord.
Then, so the 377-4 has no relevance.
Yes, my lord, come to the 371, 4, my lord.
Huh?
Where the offender is not raised.
370,
57A,
357A,
A4,
357A,
A4,
yes, victim compensation.
where, for my lord, where the offender is not raised or identified, where the victim is identified, and where no trial takes place, but our case trial was took place, my lord. The victim or his dependents may make an application to the state or the district legal service authority for award of compensation.
Ah,
But our case, my lord, the trial was took place, the accused are acquitted beyond reasonable doubt, my lord. That is why, my lord, this provision is not applicable in our case, my lord.
Ah.
That apart, my lord, section 357A, CRPC has not prescribed any limitation, my lord. But the notification prescribed the
so
notification.
are you challenging the notification?
Yes, my lord, I have also challenged in the writ petition.
Okay, have you filed your affidavit?
No, lordship, in this case, I have, this is the instruction.
No, you have to file an affidavit because they are challenging the notification.
I have challenged this clause also, my lord.
You have
Limited-
challenged the notification.
Yes, my lord.
So, and to the council, Mr. Esbulwa, the learned counsel, Esbulwa, no, and Gusami, the learned counsel appearing on behalf of the petitioner submits.
Respondent.
appearing on behalf of the respondents, all the respondents.
Lordship, no.
No, you will be appearing for the state.
Lordship, I'm for one,
Respond number 1, 2, and 3.
three there, standing council, Lordship.
Okay, 1 and 2.
1, 2,
Submits.
4, and 5, Lordship.
1, 2, 4, and 5.
Okay.
Submits that you would like to file an affidavit as there is a challenge to the notification dated 18th of October 2012.
Okay.
List the matter after 4 weeks. No, list the matter again on 23rd of August 2023. In the meantime, the affidavit be filed by the said respondents without fail by 17th of August 2020.
Of Lordship.
7,
Give me your name, sir.
Yes.
Yes.
asked about the method for time being,
Why?
my lord, garnet consent has not
Huh?
reached court, my lord. BP Bora, my lord. He has not reached court.
Is where?
He's on the way, my lord,
What is the matter about?
about the non-payment of contractual bill, my
The government? Railways? Anybody appearing for the railways? Is the railway matter?
yes, my lord, kindly for time being, my lord.
We'll have it after some time.
Yes, my lord.
List the matter after 4 weeks.
No, my lord, kindly, my lord. Today,
I'm
my lord.
sorry, I can't help you. Next.
8,
List the matter after 4 weeks. In the meantime, the respondent railways shall file the affidavit.
My lord, they are, since last year, my lord, they are taking time, my lord, for filing.
I
affidavit.
can't help it when you are so urgent. Yes, Mr. Das, your matter.
This is regarding my lord, the election of cooperative society.
Oh, then,
My lord, here, my lord, the petitioner, my lord, his nomination was illegally, my lord, rejected by saying that he has not participated in last at least 3 meetings of AGM, my lord, page 65.
Hmm.
So, my lord, while election was conducted on 5/5/2022. So at that moment, he approached this honorable court. Honorable court said you have the remedy under the election.
Cooperative Society Act. Continue. Again, wait, by 12:30 will finish. 2 o'clock will take a part. Yes,
My lord. My lord, at that moment, the honorable court said that he, but the earlier order is at page 83, relevant portion.
no, what are you asking for? Challenging
Sir, we have to challenge this, the speaking order 103 page, my lord.
page
Page 103.
103. Okay, what is this?
My lord,
order?
yes, 104, if lordship, my lord, reads in the middle, my lord, page 104, line 14. From the bottom, it is on record that the society could not hold the regular annual general meeting election for last 5 years due to some legal complications, and the last annual general meeting was held on held for the year 2016-2017. My lord, for last 5 years, there was no AGM of this particular cooperative society.
Hmm.
So therefore, ground given for rejection of my for contesting election, my nomination is not tenable. Speaking order says that the society has not held a meeting for last 5 years due to some legal problems. Some cases were pending. There was some stay order. So the ground they have given that you were not present in the last 3 meetings of the AGM. So therefore, you were not entitled for contesting the election.
Last 3 meeting of the AGM.
AGM.
Okay.
So election held on 5/5/2022. At that point of time, we challenged.
No, wait, just for example, just for a minute.
My lord.
What is this election? How the election is held?
Yes.
You were the president earlier.
No, my lord, I'm the one of the board of directors earlier.
Okay.
Yes,
Board of Director of the Cooperative Society.
yes,
Now, every
5 years.
5 years?
Yes, ma'am, 5 years.
No.
Election is-
When is the election to be held? As per this,
As per this, my lord, every after 5 years, my lord.
annual general meeting,
Is AGM every year, my lord,
AGM is 39.
39,
Okay, now election is 41.
41.
41, let us see what is the per
Yes.
year, the
The
superintendent.
superintendent's direction and control of the preparation of election electoral roll
Before the
for the
expiry
conduct of
term
election
the board
cooperative
shall
shall
be
vest
renewed
the
at
register.
newly presented demand. What is the tenure of the board? Where do I get it?
5 years, my lord.
Where is it?
Yes, tenure is 5 years, my lord, 44, my lord, section 44.
Where is it? Except as otherwise provided, although all questions brought before the meeting and shall be decided by a majority. Where is it?
My lord, section 40, my lord,
40.
40.
44. The period of
subsection
5
4.
years have elapsed from the date of a year. No, I will. You see, the term is 5 years. Where do I get it?
Yes,
Section 42 terms of directors.
Huh?
Section 42, my.
terms of
The
directors.
tenure
5
of
years,
an
42 months.
office of the year shall be 12 from the date of the election, provided the tenure shall be 14 minutes with the tenure of the board. Terms of year. Okay, now you were a board director.
Earlier.
Now, board director, if you are a board director, you wanted to contest the election again for the board of directors.
Yes,
This was disallowed on the ground that you did not participate in the AGM for 3 consecutive times. Now let us see which are the disqualifications. Eligibility for a director is what? Subject to such conditions as may be prescribed in the bylaws, a member of the shall be eligible for such member has a right to vote, such member has so and so. The period of 5 years have elapsed on year not conducting or wrongly conducting the annual general meeting of so and so, non-submission of annual, non-conducting meetings of so and so, absence from the board meetings under subsection 7 of section 3.
my lord,
The
directly
director
proceed
fails
to
here. So it
47.
is 43-7.
Yes,
If a director fails to attend 3 consecutive meetings of the board without the permission of the president or the chairman, he shall cease to be a director from the date of the 4th meeting.
I was never been
And this
disqualified.
also is a disqualification in terms with section 44.
Man.
D.
I
Now-
was-
Now,
Never
what
been-
has happened in your case?
My lord, here, my lord, I was never been disqualified.
No, forget about disqualified. Did you participate? Did you attend the 3 consecutive meetings or not?
My lord, so far, last consecutive meeting means, my lord, from 2022, prior to that, from 2016, 17 was the last meeting, my lord.
There were no meeting of the board.
In between, there are no meeting. Up to 2022.
Okay.
So,
Then-
their ground given that you were not present for last 3 consecutive meeting. Last 3 consecutive meeting is not tenable, madam.
Because there was no meeting.
No meeting. This is
So
the
that is
finding
your
of the
ground. That is the only ground you have.
only, and subsequently, my lord, other persons, at least 35 persons, whose predecessor were the fathers, they were the members of the society. Their, my lord, inheritance, my lord, their sons, they wanted to be the member. There, my lord, without upgrading the election, that the election has been done. This is our case, my lord. So it's a election is a democratic process, my lord. The election has to be done, conducted by upgrading the voter list as per law, my lord. So on these 2 grounds, this impugn election is not tenable, my lord. And my rejection 104, my lord, second para. 104 page, my lord, second para.
Yes. Where is it? On the date
104,
of
my second.
submission of the nomination,
Yes.
Sri Mora had filed his nomination on the basis of the voters list published for annual, but his nomination was rejected owing to his absence in the annual general on 2 occasions within the last 5 years, as is required under so and so.
Yes. This is same.
And thereafter, he will have filed his petition on the voters list. So on 2 occasions.
It says 2 occasions, my lord, now.
So you require 3 occasions.
আপনারা দেখেন প্রসিকিউশন করে
You have not read your file.
No, I have, Malad, page 67 is the order, Malad, the representation we have submitted before the deputy commissioner that our Malad, nomination was illegally rejected.
No, I'm not concerned
Yes,
here.
2 occasions,
See.
it's a speaking order.
Now, is it 2 occasions or 3 occasions?
2 occasions.
Section 40, subsection 2,
40,
subsection 2.
subsection 2. Such member has, 40.
Yes, 40.
Such member has patronized the services of the cooperative during their remand and has attended this
2 annual sessions.
annual general meeting in the previous 5 years. So it is under 42, not 44C.
No,
42.
So you have not attended.
As per them, my lord.
As per you,
My is that, my lord, there was no meeting held.
okay,
There was no AGM.
go to the civil court. Go to the civil court. How
Madam,
can
kindly
this
see,
court
madam,
decide?
My contention kindly.
Now, how can this court decide?
So let them show from the record, my lord, the cooperative society, let them file affidavit on this count from the record showing that there was AGM and I have not participated. My contention, now from the impugn order.
Madam, you have said that there was an AGM.
my lord.
There
No,
was AGM. He says that there is no AGM. Have you said
Because of the pendency of the cases before this.
there was no AGM?
No AGM.
Then how you are bringing in 42 then?
Because last election was held on 26, 27, or 26, 27. Sorry, 2016, 2017.
Okay, then
Now it refers to the meetings before 2016, 2017.
but here the term
That
is
will
for
be
the last 5 years, na?
Yeah.
It has been mentioned 42
yes.
says 5 years.
Since there was no meeting in the last 5 years, my lord.
Then and have attended
it-
at least a month in the previous 5 years.
Because of the pendency.
So there
of
was
the
no
cases.
AGM. If there was no AGM, where is the question of
Participation.
attending the meeting? 42, how does it come in?
Prior to 2016, 17.
But we are not concerned. Here it just say has attended at least 2 general meetings in the previous 5 years.
Because as per act and rules, madam, the meeting is to be held every year. Because of the pendency of the court, case in
Understood.
the court and
But
they also
madam-
passed by the
No,
honorable
but
court.
madam, here is the case where there was no meeting for the last 5 years.
Because of the.
Well,
stay
whatever
order
may be.
passed by the-
If there was no meeting for the last 5 years from the date of taking into account his nomination, so does this 5 years has to be taken from the date of his nomination?
But before 2016, 17, 2 years he did not attend the meeting.
But this happened when? 2022.
Yes, my lord. 5/5/2022.
So
Because
22 will be
2016,
2017.
17,
Yes.
the meeting has been held in 2022,
So the last meeting was held when?
2016, 17.
No. There has to be a date.
Date, of course, it's not with me. I can confirm it.
Now what is the consequences? The entire AGM goes.
Yes, my lord, because as per rule, my lord, we have submitted representation before the election authority, my lord, this is the direct, my lord, register.
Hmm.
Our representation, my lord, lawsuit fine.
And how
But
how has the register taken note of that aspect to the matter?
Therefore, my lord, 104, I have, my lord, pointed out, my lord,
Hmm.
para 2 and para 3, my lord.
What is that? In the annual general meeting held on a month, out of 86, 54 has participated. Total so and so, no complaint was received by the returning officer during the election. In the annual general meeting, 15 persons were chosen as the board of directors. It is on record that the society could not hold the annual general for the last 5 years due to some legal complications. And the last annual general was held in the year 2016-17. Society has been managed by the Officer of Management reputed by the department and so on and so on. As regards the issue of the multiple voters from the same officer. Now, we are only concerned with paragraph number 2.
2 and my lord 3, my lord 14 line from the below.
What is that?
It is on record. My lord, his answer now kindly see, my lord.
Ah.
It is on record that the society could not hold the regular annual general meeting election for last 5 years
Hmm.
due to some legal complications, and the last annual general meeting was held for the year 2016 and 17.
Hmm.
So this is self-contradictory, my lord.
Okay, then,
The society had managed by an officer on management deputed by the department, and
time of-
no regular board of directors could be formed. As a result, no major decision could be taken with regard to inclusion of voters, insertion legal heirs as voters, etc. Accordingly, it was resolved as a meeting held on 5/5/2023, date of election, my lord, for inclusion of such members in the voter list, then assigned the task of new
so we are only concerned in this petition as regards
my
your
rejection.
rejection. Now, what is the consequence of your rejection being overturned?
My lord, while
Who is
declaring
appearing for this corporation department? Very fantastic.
but they have not filed their affidavit also, my lord.
You want the affidavit?
I don't want,
Then?
but if they contrary,
Why did you pass over for time?
so let this matter come up next week. If they have any instruction, they can get. My lord, so far the election is concerned, by speaking order is very clear.
No,
And
the
under
speaking order does not take into account that as 42 in the proper perspective.
My lord, yeah.
Now, the effect of the effect would, what would be the effect would be,
Effect, my lord, therefore I was submitting, my lord. Section, rule 27 of election rule, my lord,
Ah.
cooperative society.
where is that? Here we have it.
Yes, there is a, my lord, gets circular, my lord. 27 after the, my lord, issuance of election notification, we cannot raise any question. Therefore, the honorable court directed to go before the raise the within 3 days. Rule
Then?
27.
Then,
After the election, we approach the raise the, my lord, ventilating all our grievances by filing our application dated 7/5/2022.
now who is the election authority?
My lord, raise the. Raise the is the election.
And this is the order.
And this is the order of the raise the, my lord.
And this you have challenged under 226.
Yes, my lord. So therefore, it has to be, my lord, in my whole submission, my lord, not tenable, my lord. Our representation, page 88. Page 88, my lord.
What is that?
Yep, of the repetition, my lord.
No, no, Mr. Das, why you are asking this court to move from this place to the other? Your simple point is 42 have not been complied with.
Complied with, and therefore.
And there couldn't have been, the 5 years has to be taken into account from the date of your date of on which you have filed your nomination.
Yes,
So the 5 years prior to that, there was no election
no election.
and no AGM. And as such, the question of not participating in 2 AGMs does not arise.
Yes, my
Isn't
lord.
that your case?
Deeply.
Why you are making it long and short
Now, because lost.
unnecessarily? You have spoiled enough time of this court. So and so the corporation department, the counsel for the corporation department is not available upon being called for. List the matter next week.
Obliged.
9,
Yes,
My lord, the matter may be adjourned for the day, my lord. My senior is.
at the request of the learned counsel, matters can be adjourned for 6 weeks.
10,
Your Lordship, this matter will be taken up by A.H.M.R. Chaudhary, but he could not appear before the Honorable Court today as his mother is seriously ill.
Let the matter be listed after 6 weeks at the request of the petitioner.
Your Lordship, finally, maybe tomorrow.
6 weeks.
11,
Yes, Mr. Hussain.
My lord, in this case, my lord, son of the petitioner died in electrocution, my lord.
Oh.
Accordingly, my lord, the petitioner.
Electrical incident report?
Yes.
We have filed?
No, it is not.
You have got it?
Okay.
Have you given him a copy?
So I did-
When? When did you get it? You file it by way of an affidavit, bring on record.
Look.
Give him a copy. You don't serve a copy to him.
No, we'll find, we'll start.
You don't serve a copy to the this APDCL.
We'll start. But
You don't. The Mr. N. Goswami, the learned counsel appearing on behalf of the state respondents, submits that the electrical accident report have been received. And he would be placing on record by way of filing an affidavit. So list the matter after 2 weeks, list the matter on 7th of August 2023. The affidavit be filed by 4th of August 2023 by serving the advance copy to the counsel for the petitioner as well as the counsel for the APDCL. The learned counsel appearing on behalf of the APDCL shall also inquire as to whether the APDCL authorities have also initiated any action against the electrical accident report. In the meantime.
Well,
Yes.
This is third round of litigation.
Yes.
Last order, your lordship may kindly see page 181, my lord.
What is this matter about?
Matter relating to my petitioner is challenging the termination of contract as well as forfeiture of my lord bank guarantee, your lord. Because of the my lord compelling circumstances during COVID, there are circular also. And this honorable court has given my lord opportunity to complete the work. And work was accordingly, my lord, contract was extended to July 2022. But before that, my lord, they have terminated my contract. One day before, they are saying my work is in good progress. Thereafter, second day, my lord, again they have issued notice, your lordship, and that's why this honorable court, page 181, directed railway to sit. And
Now, what is happening to the contract now?
my lord, they have given contract to somebody else, your lordship.
At your risk and cost?
Also terminate. That person could not complete,
No, your contract has been terminated.
terminated.
Now, what stay you have got?
Stay because my lord, this honorable court directed the authority to sit and amicably settle the issue. But my lord, what they have done, they have whatever happened earlier, they have quoted that one, and they have again decided that my forfeiture and termination to be valid. My lord. That has been challenged.
Forfeiture?
Forfeiture of bank guarantee, my lord, and termination order. My lord. If termination goes, my lord, the question of forfeiture will not arise.
No. You are challenging the termination.
Termination.
Why?
Because my lord, the termination was done, my lord, despite the work was in
No, what order has been stayed by this court?
My
On
lord, that-
18/8?
my
Which
lord,
one?
page 185. This is the order passed in pursuance to the order
18/8.
passed on
In
24th.
view of the deliberation remand, there is no public interest will be satisfied with waiving the terminated contract. Keeping taken twice earlier and go up the balance. Is a should be further. The action taken. Now, isn't there an arbitration clause?
My lord, arbitration clause, my lord, but this matter may not, because your lordship, prima facie, this court, they have also not raised in their affidavit.
Then they don't raise this to the.
My lord, but
Where's the union? No union.
the GSC is appearing, your lordship.
Ah,
Earlier railway standing council was there, your lord.
no union.
And for that, my lord, I will place, my lord, I will satisfy your lordship, this case, my lord,
For what?
regarding arbitration, my lord.
Yes, arbitration. Tell me, why should this court decide as to whether the
Because
termination
clear-cut
is right
violation,
or
my
wrong?
lord, clear-cut violation of the order passed by this honorable court, number one, my lord, the notification issued in respect of,
If there is an order being passed in violation of this court's order, then
Yes.
obviously it will be a null and void. So that can already be decided in the arbitration. Why you are not moving a section 11?
my lord.
And moving
since
this week.
court has given, my lord, relief to me, your lordship.
So this
And my lord,
earlier the courts were lenient. This court is not.
I don't know, linear, this court is also, my lord.
This
my
court
lord,
is not lenient for
your
that
lordship,
purpose.
so far as my lord, tax part is concerned, that I will place law, my lord, your
No,
lordship.
why these aspects of the matter,
And my lord,
whether there is a termination, why don't you go there?
my lord, FS courts, my lord, in one of the decision held that, my lord, if the other side,
Uh.
they have not raised the question of arbitration. And prima facie, there is a violation of principle of natural justice. And my lord, in that case, my lord, report, my lord, because this is, my lord, they are saying alternative remedy. There cannot be, my lord, alternative remedy to 226, my lord. It may be additional remedy, your lordship. 226
No,
should be,
there
my
is an
lord.
alternative remedy.
My lord,
There is
in
no
my
alternative.
humble submission, my lord,
No,
there cannot be alternative remedy to 226. It may be additional remedy, your lordship. 226 remedy arbitration, arbitrator, my lord, arbitrator doesn't have, your lordship.
What?
So far as the power given under 226, my lord, that power is not with arbitrator, your lordship.
Why?
My lord, because that remedy is not so efficacious as 226, your lordship. So that's why, my lord, I am before your lordship. 2 rounds, your lordship. This honorable court was pleased to, my lord, protect me, my lord. And last order, your lordship will see that has been violated, and this order has been passed. Page 181, my lord. Hello, arbitrariness is there, your lordship. One day before they are saying, my lord, you are working very good. Second day they are saying, why not your contract should be terminated?
Why? What order is in violation?
Well, page 181, your lordship.
I read that order. This
Here,
order
your
doesn't
lordship,
say
it
anything.
says, my lord, be that page 183, your lordship.
I've read it.
My lord. So they have been directed, my lord, to consider a phrase. But what they have done, my lord, whatever done earlier, on that basis they have done.
So they have considered it.
No, my lord, considered a phrase, phrase circumstances. That has not been taken into consideration. Your lordship will see the impugned order.
The counsel for the petitioner appears and has submitted that he has already filed an affidavit in reply against the affidavit in opposition filed by the respondents. The learned counsel, there is no counsel who has appeared on behalf of the respondent railways or for the Union of India in spite of their names being shown in the cause list. List the matter again on 14th of August 2023.
My lord, before
In the interim order passed earlier shall continue till then.
my lord, before 14 or after 14.
Okay, we'll have it on 11th of August.
Deeply applied.
And about 13 to 17.
Well, the concerned respondent has filed an affidavit in opposition, respondent number 2, and at paragraph 6 may kindly be looked into at page 37. It has virtually admitted that
This is for non-payment.
Yes, madam.
Yes.
It is paragraph 6 at page 37. Sir.
How much amount? 15 lakhs, 76,000, 7,767.
Yes.
Okay, this is water resource, which department?
The water is good.
Water resource. Do you follow Tamsil Ali?
Yes, sir.
What is the citation?
I'm sorry. Yes, ma'am.
Lordship, but the deputy commissioner is to make the payment. We are just the executing body. Lordship.
2008 Port GLT page 1.
2008 4 GLT page 1. Yes, Mr. N. Goswami, you are to make the payment. You make the verification and do the verification has to be made by whom? The water
He has
resource.
already done it.
Verification done. Lord.
Deputy
So they are entitled to.
Yes, sir.
When are you paying? Deputy Commissioner?
Because the money has to be brought to the deputy commissioner ceiling amount. He has also said.
4 months from the date a certified copy of the order is submitted. The instant petition has been filed by the petitioner. Being aggrieved by the inaction of the respondent authorities, এইটো গোটেইকেইটাত বেলেগ বেলেগকে হ'ব দেই। এটা মই dictate কৰি দিছো, বাকী you do it. Being aggrieved by the inaction of the respondent authorities in not clearing, in not making payment of the legitimate dues of the petitioner. Full stop. The brief facts of the instant case is that on 19/5/2017, the Chief Engineer, Water Resource Department had invited bids for approved and eligible contractors for works under the SDRF. Full stop.
My lord, may I take your leave, my lord, the division bench matter?
Okay, let these matters be
Okay, well,
listed
sorry,
up for
sorry,
4
sorry.
weeks. 4 weeks.
I'm sorry, madam.
Let it go.
Chief,
Let these matters be listed after 4 weeks.
I'm all right. Sorry, madam.
18.
কি লিখতে? Utility number of educated monthly. Yes.
Forest lordship matter relates to the non-payment of contract work done by the present petitioner lordship. Here, the Union Authority has took up a project for creation of 200 hectare mixed plantation under Kosutal Baltira area within inner line RF. Lordship kindly come to the annexer.
Where is your instruction?
Forest
Huh?
Forest. Annexer 1, page 14, lordship.
How much amount?
Amount
25 lakh 60,000.
is 25,60,000 here.
When was the notice issued?
Notice of the chair, last 1 year, lord, they are taking time for instruction, lord.
Forest
This is
Department.
the file of the petition, lord. They have also, work has completed, they have issued the notice, lord, kindly come to the page. Range Forest Officer has also wrote a letter to the Division of Forest Officer, lordship. Page 17, lordship, next up 4, lordship. Page 17, next up 4, lordship. Regarding engagement of daily laborers for creation of 200 hectare daily laborers and payment of wages thereof, lordship. This office letter number 20, so.
Okay, leho. The case of the petitioner herein the instant writ petition has been filed by the petitioner being aggrieved by the non-payment of the contractual bill of the petitioner to the tune of rupees 25 lakh 60,000, as well for labor wages, and rupees 60,000 for bamboo rhizomes, RHIZOMA, along with suitable rate reasons. The petitioner have also prayed for interest at the the case of the petitioner herein is that the respondent number 5 that is the Divisional Forest Officer, Hailakandi Division, by an order dated 3/7/2021, directed no, asks the petitioner to supply 5,000 numbers of local bamboo stump for planting in the covered Mizo encroached area at Kachuthal Balichera area under Matizuri range. Full stop. Thereupon, the respondent number 6, that is the range officer of Matizuri range, issued a work order on 5/7/2021 in favor of the petitioner for engagement of daily labor for creation of 200 hectares mixed teak plantation at Kachur Des Balichera area in 4 blocks within Inner Line RF under Matijuri range immediately. It was also mentioned that a payment of wages will be paid against Master M roll after receipt of the fund. Subsequent thereto, on 7/7/2021, the respondent number 6, that is the range officer of Matijuri range, gave a receipt copy to the petitioner that 2,000 numbers of bamboo resin were received by the office of the respondent number 6. The petitioner claims that after completion of the projects, the office of no, the petitioner further states that on 26/7/2021, the respondent number 6 issued a letter to the respondent number 5, stating inter alia that 6,400 numbers of daily laborers were engaged in creation of 200 hectares mixed teak plantation at Kathurtot, Des Balichera area in 4 blocks with Inner Line RF under Matijuri range. It was also mentioned that the advanced work and planting, etc., have been completed in 200 hectare plantations. It is the further case of the petitioner that in spite of such letter being written and the work being completed, the respondent authorities have not made payment to the petitioner, for which a notice was also issued. However, the respondent authorities have not replied to the same.
On page 27 annexure C, Lordship.
Have also notice have also been issued to the respondent. It has also been mentioned that the respondent number 2, having after receipt of the notice, issued a letter to the respondent number 5 for furnishing a detailed report on the matter, but till today, till the date of filing of the writ petition, there has been no payment made to the petitioner, for which the petitioner had approached this court by filing the writ petition. It appears on record that this court had issued notice on 14/9/2022. Till date, the respondents have not filed any affidavit. I've heard the learned counsels for the parties. The learned counsel, Mr. K.P. Pathak, appearing on behalf of the Forest Department, submits that the fact as to whether the petitioner has actually completed the work or not is subject, requires to be verified, and it is only upon proper verification the actual entitlement of the petitioner could be ascertained. Upon hearing the learned counsels for the parties, this court is of the opinion that the facts, the opinion that the entitlement of the petitioner as claimed in the instant writ petition would depend upon verification to be carried out by the respondent forest department to the effect as to whether the petitioner had duly completed the work, the work and to what extent. This verification has to be made in the level of the respondent number 5 and 6
Do your lot. PCF, let the PCF do it, your lot. Then
by the respondent number 2, 5 and 6.
Correct.
2, 5 and 6. Full stop. Accordingly, this court therefore disposes of the instant writ petition with the direction to the respondent number 2, 5 and 6 to make necessary verification as regards as to whether the petitioner had duly completed the work and in terms with the work order dated
3/7/22.
5/7, na? 5/6.
3/7.
Work order dated 3/7/2021 and 5/7/2021. And upon verification, if it is found that the petitioner is entitled, the said amount be paid to the entitled to certain amount, the said amount be paid to the petitioner within a period of 4 months from the date a certified copy of the instant order is served upon the respondent number 2.
19.
Yes.
The lordship, this case for non-release of payment for requisition of vehicle, lordship.
We have the instruction logic. Amount had with the
The instant writ petition has been filed, being aggrieved by the inaction of the respondent authorities in not making payment of an amount of rupees 16,18,609 to the petitioner for clearance of the for which the petitioner claims to be entitled to on the basis of the requisition of the Bolero vehicle bearing registration number AS09-E-5744 from 1/3/2017 to 3/7/2021. You could have bought a car like this.
lordship.
You could have bought a car with 16 lakhs.
Lordship.
Bolero is not 16 lakhs.
Lordship.
The case of the petitioner herein is that the vehicle of the petitioner bearing registration number AS09E5744 was requisitioned by the Hosai DEF under the Assam Requisition and Control of Vehicles Act 1968 with effect from 1/3/2017, and the vehicle was released by the MTO Police Reserve Hosai on 3/7/2021. Full stop. The petitioner claims an amount of rupees 16,18,609 as the amount to which the petitioner is entitled to on account of such requisition. Full stop. Being aggrieved by the non-payment of the said requisition amount, the petitioner had approached the respondent authorities. However, the respondent authorities having turned a deaf ear towards the request of the petitioner has filed the instant writ petition. It appears on record that this court, it's already here. It appears on record that this court had issued notice on 19/9/2022. Mr. N. Goswami, the learned counsel appearing on behalf of the petition, on behalf of the state respondents, submits submits on instructions on the basis of an instructions dated 26/9/2022, whereby it has been admitted that the vehicle of the petitioner was requisitioned for the period from 1/3/2017 and was released on 30/6/2021. It has also been mentioned that the total due compensation to which the petitioner would be entitled to amounts to rupees 18,51,798. Further to that, in the instructions, it has also been mentioned that the higher charge bills have already been sanctioned. Some of them, that only 4 higher charge bills have been sanctioned.
There's another, next page.
What are these? The said instruction so handed over by the learned counsel for the respondent is kept on record and marked with the letter X. Taking into account that the respondent authorities have duly admitted the requisition of the vehicle from 1/3/2017 and to 30/6/2021, and have also admitted that the petitioner is entitled to a compensation of rupees 18,51,798. This court is of the opinion that it will be in the interest of the justice that the direction be issued to the concerned respondent authorities for making payment of the said amount within a time frame. Accordingly, this court therefore directs whom?
DGP law.
DGP law.
DGP. Huh?
Director General Police, that's number 4.
Accordingly, this court therefore directs the respondent number 4 to make payment of the amount of rupees 18,51,798. He asked for less, you have said more.
No, some amount has been paid. Total amount was that, subsequently that amount, some amount has been paid.
He doesn't say that he has got any money. Have you got any money?
Later, it was revealed that some amount,
Some amount has been released
but that
also.
was before the filing of the case, Your Lord.
At the time of filing of the case, he had 16,18,000. Your instruction says that he is entitled to 18,51,000. Then, which is right?
So, Lord, actually, we have received instruction that the actual amount is the stated amount by the SPO police is correct.
Obviously, you will like that. It's 2 lakhs
We
more.
have the bills also, Your Lord. We also have the bills for that.
But why are you asking less then in your
At the time,
petition?
we did not get the full like the instructions, Your Lord.
Accordingly, this court therefore, within the time. This court, however, cannot be also unmindful of the fact that there is a discrepancy in the amount so claimed in the petition, inasmuch as the petitioner had claimed an amount of rupees 16,18,609, whereas the amount which have been admitted by the respondent authorities is an amount of rupees 18,51,798. Taking into account this court, therefore, disposes of the instant petition with a direction to the respondent number 4 to make verification as to the actual entitlement of the petitioner, and thereupon to make the payment of the entitlement of the petitioner within a period of 4
months.
3 months.
3 months.
Within a period of 3 months from the date a certified copy of the instant order is served upon the respondent number 4. Petition accordingly stands.
I have 20.
Yes.
Hello. The petitioner with your lordship is agreed by disconnection of the electric connection in this house. Case 38 is the impugned communication.
Who are you?
Malad, I have a shop in that area. I have an electric connection in my name.
You're a tenant.
No,
Okay, then
there was a dispute with regard to that shop with the neighbor shop house, and there was a 145 proceeding initiated. Now that 145 proceeding, the executive magistrate decided the title of the in respect of both the parties. Subsequently, thereafter, on 22/8, page 38,
then
page 38, by this letter, my lord, my electric connection was disconnected. This is a letter dated, my lord, 22/8, and my disconnection has been done on 22/8 itself, on that day itself.
then
It shows, my lord, this has been done.
honor to inform you as per the order dated so and so from the so and so the land recorded in the name of Lupong under so and where your service connection is installed. Therefore, your service connection will be disconnected with effect from Iman as per the letter dated so and so. Now, what is this dispute?
This letter dated 30/07, my lord, was never served upon us. Now, the order of the executive magistrate, this letter dated 30/07/2022, which has been referred,
Yes.
that was never served upon us. And this order of the executive magistrate is of 8 of August 2022. After this 37/2022, and on 37/2022, the executive magistrate did not decide anything in the 145 proceeding. The executive magistrate decided only on 8/8/2022, which was subsequently we challenged that order before this honorable court, and this honorable court has interfered with that order.
Interfered means set aside.
Set aside that order, remanded back the matter to the executive magistrate for press hearing.
Yes, Mr. Pathak, what remains?
Lordship, perhaps,
Restore.
yes, let the,
Because if you have done it on the basis of the executive magistrate's
Yes.
order, that order have been set aside.
yes,
So I think you restore it.
yes, Your Lordship. Perhaps this order may be set aside and the petitioner may be directed to submit the documents which he had submitted under clause 4.2, then we can revisit the order.
Oh, what revisit the order? Restore.
We'll restore it. Let him just submit the documents under clause 4.2.
You will submit. That's a different thing. Because the basis on which you have taken the
Yes,
action
that is no
is
longer.
no longer there. Heard Mr. B. The instant petition has been filed by the petitioner, being agreed by the order dated being agreed by the disconnection of the electricity connection. Electricity?
Connection.
By the electric connection, or what do you say? By the
Electricity.
by the electricity by the disconnection of the electricity connection. Wide on the basis of a communication dated 22/8/2022. A perusal of the said communication reveals that the said communication was issued on the basis of an order being passed by the court of the additional district magistrate Dhemaji in case number 16M/2022, registered under section 107/145 of the CRPC. The learned counsel appearing on behalf of the petitioner though submits that the said order passed by the learned additional district magistrate did not deal with the disconnection. But no, listen. However, he submits that irrespective of that, the said order dated 8th of August 2022 passed in case number 16.M/2022 have already been set aside by this court in criminal revision fee number 470/2022. And as such, the entire basis of the disconnection of the electricity so made by the communication dated 22/8/2022 does not survive. In this regard, the learned counsel for the petitioner had placed on record the order dated 7/6/2023 passed in criminal revision petition number 470/2022 by this court, whereby the order dated 8/8/2022 was interfered with on the ground that the said order was passed beyond the powers of the district magistrate. The said order dated 7/6/2023 passed by this court in CRP P 470/2022 is kept on record. Mr. KP Pathak, the learned counsel appearing on behalf of the APDCL submits that as the entire edifice of the order dated 22/8/2022 was the order dated 8th of August 2022 passed in case number 16M/2022, and the said order having been interfered by this court, the order, the communication and the communication dated 22/8/2022, as well as the disconnection made on the basis thereof, do not survive. Upon hearing the learned counsels for the parties, this court therefore, taking into account that the entire basis of the action of the respondent APDCL to disconnect the electricity connection of the petitioner being the order dated 8th of August 2022, which no longer survives. The communication dated 22/8/2022 is therefore interfered with, and the respondent APDCL is therefore directed to restore the electricity connection to the shop of the petitioner. Shop of the petitioner. Full stop. It is further the petitioner is directed to restore the connection to the shop of the petitioner forthwith upon submission of a certified copy of the instant order, along with the details, along with
The documents required under clause 4.2.
along with the documents required under clause 4.2 of the
AERC Electricity Supply Code 2017.
the above the petition.
Highly blessed.
21.
Yes.
Yes, but the son of the petitioner died due to electricity.
Oh, electricity, electrical supply. You have brought in account causes of the accident from the it appears the electricity was occurred due to leakage, fall, current flows through his body as a result of which the victim contravention demand on the part of the owner of the building who is responsible to maintain the installation under his control. Who is the owner of the building?
It is not a party here.
It's not a party here.
Is not on the fault of the APDCL.
No. I
Then-
think it has happened inside the building.
Then how do you get this 4 lakhs? I think you better go to the civil court.
It's not a It is strict liabilities follows lordship. The supplier is primarily liable.
No. Wait. এখন কাগজ কোন কোথায়? এনে দিয়ে গেছিল না নীলাঞ্জন? Eka has given something. You have that memorandum,
Yes.
office memorandum?
Yes.
Yeah. There it is clearly mandated that this 4 lakhs will be paid only when it is attributable to the ACB by APDCL. Now, if it is not attributable, isn't it the case of AR? Here you see. Along with the quantum of compensation payable for the loss of human life and injury where the accident is attributable to the false negligence of the APDCL. Now, if the accident report says otherwise, I think you have to then move the civil court.
Yes.
That is the best way out.
Does the MP electricity board file Kumari Lordship?
Which one? That is the state. You are saying about the boy.
Okay.
About the boy's accident. That case?
Lordship, no, Lordship, the law laid down.
What law?
Yes, Lordship.
Show me.
This is paragraph 8. Lord.
This one, and the 1 crore was given.
Yes.
That was 1 crore 25 was given by the High Court, it was given. But that was the thing which had happened with the government. That was done by these people out there. This was a case where it was filed out there in the High Court, it was done. You see, a compensation claim was in the sum of ₹6 point. The trial court assessed the compensation. This was done before the civil court.
This arose out of proceedings starting from the civil court, Your Lord.
So you better off, I think.
Yes.
I don't say much on this. I say that you want to withdraw in view of the electrical accident report.
Yes.
And pursue
Yes.
in the before a civil court. Then you can get hold of ACBOs. Yes, the learned counsel appearing on behalf of the petitioner submits that in view of the electrical accident report as brought on record by the affidavit dated 16/2/2023 by the Chief Electrical Inspector cum Advisor, Government of Assam. The petitioner would not like to press the instant writ petition, but the learned counsel further submits that withdrawal of the instant writ petition should not prejudice the petitioner to approach the appropriate forum for redressal of his grievances.
Limitations could be
What limitation? He died in 2021.
Yes.
You have time till 2024. Oh, you have time.
Okay.
Good stop. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. The petitioner would it is made clear that the withdrawal of the instant writ petition shall not preclude the petitioner to approach the appropriate forum seeking redressal of his grievances. Mr. Pathak, I'm keeping this. It's required. And what is it?
This is the ARC Gazette of the
This is
order
that,
on the basis
because
of
all the other lawyers keeps giving me that one, what you call the draft one.
this is the Gazette notification of the ARC, Your Lord, on the basis of which the notification has been issued by the APPC.
Okay. And give it to that lawyer, it may help you. List the matter.
Next week.
List the matter again on 4th of August 2023, along with the sage affidavit.
23.
Maybe the Lordship. Lordship, here in this case, Lordship, for non-payment of victim compensation amount, Lordship, there is a notification, Lordship, in the year 2017. Lordship, case 46, Lordship. Lordship, that it is awarded, Lordship, one-time payment, Lordship, 10 lakhs to the victim of special ability victim, Lordship.
Where is it?
Lordship, case 46.
Now you have not got that amount.
No, Lordship. So already 5 lakhs has been awarded by the district legal service authority, Lordship. But the remaining 5 lakhs I have to take inspection. At least can you remember Thursday, Lordship, that I can take some inspection.
Lordship, can be Lordship. Last inspection in the record, Lordship. But the order sheet is not reflected.
Hey, So the district legal services have paid you 5 lakhs.
No, Lordship.
Not a single penny has been paid.
That is the central Lordship. That is my awarded Lordship.
Where?
Lordship, 5 lakhs is my awarded Lordship.
No, 5 lakhs have been only deemed fit to amount of 5 lakhs be awarded.
Yep.
The payment has not gone.
Not for
Then what about the remaining 5?
Lordship.
Why have you thought about giving less 5?
No, they will give. No. So I
And why this district secretary, the DLS Kamrup has only made 5 lakhs when the this
Okay, sir.
particular notification was clear?
Lordship.
Who is this district here? S. Dotto. The petitioner herein is aggrieved the petitioner being a rape victim, na?
Rape, yes.
The petitioner being a rape victim,
So, petitioner's daughter,
petitioner's daughter, she died.
not,
The rape victim died.
is mentally, no, not died, is mentally disordered.
The petitioner being aggrieved by the non-payment of the amount of rupees 10 lakhs in terms with the notification dated 6/1/2017. Whereby it has been mentioned that the compensation of rupees 10 lakhs would be paid, would be provided to the specially abled woman rape victim under the Assam Victim Compensation Scheme 2012
May I submit?
has approached this court under Article 226 of the Constitution. It appears on record that the Secretary District Legal Services Authority, Kamrup Metro, had passed an order dated 28/2/2023, wherein an amount of rupees 5 lakhs was awarded as compensation to the petitioner. Was awarded an amount of rupees 5 lakhs to the victim, which as per the Secretary District Legal Services Authority, Kamrup Metro, was the maximum amount prescribed to be paid on account of rape of the victim as per serial number 3 of the schedule under the Assam Victims Compensation Scheme 2012. It appears that the Secretary District Legal Services Authority, Kamrup Metro, did not take into consideration the notification dated 6/1/2017, whereby the compensation was enhanced to rupees 10 lakhs to be provided to specially able woman rape victim under the Assam Victim Compensation Scheme 2012. The learned counsel, Mr. N. Goswami, appearing on behalf of the state, submits that he needs an accommodation for 2 days to take appropriate instruction in the matter list the matter again on 24th of July.
Your Honor, one more thing, Your Honor, in the year 2017, after that, in the year 2019, one more notification is there, Lord.
What is that? It makes it 5 lakhs.
Yes, sir.
Lordship, in this, that notification is not covered in present case. As because Lordship, the subsequent notification, it is enhanced, the earlier notification. It is only for general rape victim, Lordship. But here in the special case, Lordship.
তাৰ আগৰ লাইনটো লিখিব দেই এইটো has sought for an accommodation আগতে লিখিব হা your name
Deepika Das, G Das,
appearing for
respondent number 3, on behalf of.
G Das appearing on behalf of the respondent number 3 however submits that by a notification dated 1/2/2019 the compensation to rape victim was increased from 3 lakh to 5 lakhs, and it is on the basis thereof the Secretary District Legal Services Authority Kamrup Metro had granted the maximum amount of rupees 5 lakhs. On the other hand, the learned counsel appearing on behalf of the petitioner submits that the victim is a specially able rape victim. And as such, the notifications to which would be applicable is the notification dated 6/1/2017. তার পিছত লিখিব he seeks an accommodation. ঠিক আছে?
On 24th.
Yes.
Highly.
But why the 5 lakhs has not yet been paid?
The sealing order yet not received by the Assalta Lordship.
Huh?
The sealing order yet not received by the Assalta Lordship.
You are not
The budget
concerned
is
with that.
sanctioned.
This is after all, it's a rape victim. You have not made the payment.
Yes, Lordship, the budget is sanctioned, Lordship.
Budget is 9 crores have already been sanctioned. Why the payment has not been given? Who needs to take the payment? You.
Lordship.
When are you paying it?
As the instruction.
The 5 lakhs?
Lordship.
Why haven't you paid?
On 24th, I will inform.
The Mr. N. Goswami shall also obtain instruction as to whether the amount of 5 lakhs as awarded by the district's legal services authority have been already paid to the petitioner or not.
Highly.
You find out whether we can impose interest. Yes, who is there? 24?
24.
None appears on behalf of the petitioner. Matter stands adjourned for 4 weeks.
25.
May I please, your Lordship?
Contractual due.
Contractor will, Lordship.
Yes.
Lordship, I appear for the respondent number 4 on behalf of Mr. Ikenaya, Lordship.
Why?
Lordship, we will require some time.
Who is to pay? You can hire is to pay.
No, Lordship.
Then why you are appearing for somebody?
Lordship,
He's not a lawyer. Has Mr. Yukenaya given you a what do you call a wakalatnama?
No, I have not signed the wakalat nama, so I appear on his behalf. Lord.
But are you saying that Yukenaya also signs a wakalatnama?
No, no. Yes.
Then
Lordship, some amount was required to be paid, Lordship, and Lordship may kindly turn to page 22 once, Lordship.
yes.
Second paragraph, Lordship. Is submitted on behalf of the petitioner that the authority of Rangya College issued a letter under
Shall be paid
reference
to be
number
full
so
in
dated.
respect of construction of a part of the connected artery in the remaining amount shall be remaining. Okay, how much is he entitled to?
Lordship.
You have got 4 lakhs.
4 lakhs paid, Lordship.
Okay.
12 lakh 49,000 unpaid.
Okay.
Lordship,
Earlier it was
Lordship, it is
16
the
lakh 40,000.
Principal Lordship, you will have to.
Huh?
Lordship, it is the principal Lordship, will have to pay. Lordship.
subject to clearing it from the higher education department, Lordship. We are yet to receive those amounts.
Yes, higher education department, why you are not clearing it?
That lordship, I have to take instruction, lordship, if not,
What is
Forward.
this? No instruction. This is of 2022.
lordship, but
These matters are of 2022. You have no instructions. Who is respond number 4? You.
I am appearing.
Then the petitioner. By way of the instant writ petition is seeking a writ of mandamus, thereby directing the principal of Rongia College, that is the respondent number 4, to release the balance amount of rupees 12,49,000 along with interest from the date of completion of the work, that is 5/3/2018. The learned counsel appearing on behalf of the petitioner has further drawn the attention to the order dated 26/4/2022, passed in WPC number 7020/2021. Whereas also there is an admission for payment of the amount in installment basis as per the estimated cost after receipt of the fund from the Higher Education Department of the state. Mr. MP Sharma, the learned counsel appearing on behalf of the respondent number 4, submits that the respondent number 4 is not in a position to make clear the said amounts as the fund has not been received from the Higher Education Department. Mr. D. Upamanyu, appearing on behalf of the Higher Education Department, submits that he would like to take instructions in the matter. Taking into account the above, let the matter be again listed on 28th of August, July 2023, on which date the learned counsel appearing on behalf of the Higher Education Department, as well as the learned counsel appearing on behalf of the respondent number 4, shall apprise this court as to what is the status as regards the payment to be made to the petitioner.
Obliged.
26.
Matter, lordship, we had challenged, we participated in tender process initiated by the Seed Corporation, your lordship. We participated in a tender process initiated by the Seed Corporation. I'll just take your lordship to the price bid. In our price bid, there was a typographical error. There was just 1 0 missing, your lordship. So basically, instead of 326,000, 3,26,000, we wrote 326,000. And the tender itself says that when there is a mistake, it has to be corrected in a certain manner. So we filed representations that correction has not been done. Now, though there is an interim order in my favor, your lordship, sowing season will be over. And after that, they will cancel the tender process, your lordship. And multiple opportunities have been given to them to get the instructions for that. That has not been done.
May I please, Your Lordship? Lordship, we sought for the instruction, Lordship, but instruction is still awaited, and the matter is under consideration, Lordship.
What is this under consideration?
Actually, Your Lordship, we contact the department. They replied that they will arrange a meeting within 14 days, and they will consider the matter. But just for formal communication, we need Lordship 2 week time.
No. Sorry.
Can we take your lordship?
Friday.
Very good.
Learned counsel appearing on behalf of
Mr. S. Samoria for standing counsel.
your Samaria.
I am appearing on behalf of S. Samoria.
Did he give you a wakalatnama? Then what is your name? You don't have a name.
Yes, Lord.
What is your name?
M. Zaman, Lordship.
So and so appearing on behalf of the Seed Corporation of,
Yes, sir.
of
Assam Seed Corporation.
Assam Seed Corporation. Eh? What is that?
Assam Seeds Corporation.
Assam Seed Corporation. Assam Seeds Corporation Limited 6 for an accommodation. Taking into account that there is an interim order, list the matter again on 21st of July 2023, on which date the learned counsel appearing on behalf of the respondents corporation shall obtain the necessary instructions in that regard. Interim order partially shall continue till
27.
Yes, Mr. Monto.
My lord, this is relating to claiming from remission.
Huh?
Only remission, my lord.
Remission.
Only provision of the rule 34 and 34 and 35 of the Indian Water Transport Department. This is the central and management of the ferries rule to 1968 as amended 1978, my lord.
Okay.
So as per this, my lord, fact is that the petition was given the settlement of the ferry service. This Budrulsar Vasantapur for the period 2 year, my lord, is commencing from 22 to 24. Then after that, my lord, that was settled at the rupees, my lord, 53 lakhs 98,650. Against the base value, my lord, that was much lower. This is 2 lakhs 15,624. And after that, my lord, what happened? A few days after running of this ferry service, the petitioner realized that the amount whatever is expected, that is not coming. So reason behind is that the 4 my lord ferry service, it is given settlement by the Panchayat, violating the provisions of the my lord the High Court's my lord earlier order and the my lord the barred under the Panchayat Act also. And that was then detected and that was reported. And that settlement was not stopped by the even reporting of the things to the Inland Water Transport Department. And moreover, due to decision of the water, that is when the communication between the two pargas was difficult. So the people have to cross by on foot on by leaving the rivers, and otherwise, they have to construct 2 bridges to cross the people between the two pargas. And for this reason also, the more than 15 days, it is more than at the time of the filing of the deed petition, it is about to be completed 1 month. The ferry service was stopped. So at that provision, the 34, complying that if the ferry guard is more than 15 days is stopped. Then
Now, what has happened? Have you been paying your kist?
this money I have paid, but in spite of all my difficulties,
I have
And a
received
part
the
is
present
money.
status, my lord.
Yes.
Receive, I have the email.
Hello.
Uh,
they
Just
have,
now I have received, my lord. The department has taken over the ferry guard from the petitioner because he
Have
has
taken over.
taken over.
no, 15 days time has been given to
Given,
give
but-
the third installment.
He failed to deposit the KISS money. In fact, we have extended 1 month time earlier also, my lord. In our affidavit, we have annexed the documents, my lord. Affidavit we have filed.
So now you have taken over.
Taken over, he has given some time.
Even
if
again
we
given
can-
to us. Physically, symbolic they have taken the possession, but physically I have been given to run. Given a 15 days time to give the third kisti. Already 2 kisti we have deposited. And so far the remission part is they are totally silent. If this remission part is not given to me, I am in a very hardship now. Because the facts is remains. with
And
their-
what is your stand on the remission?
Lordship may kindly have a look my affidavit for a moment, my lord.
Where is it?
Page 43, running page, my lord.
Yes.
Paragraph 4, my lord.
Yes.
There with regard to the statement made in paragraph 11 of the writ petition, the deponent begs to state that the ferry services under the local Panchayat and Zilla Parishad were in operation before the settlement of the Badusar, this ferry service. As such, the petitioner participated in the NIT, so and so being aware of this fact. Now, his ground is that there are other ferry services run by the Panchayat department, so he is facing
Loss.
loss, my lord.
Okay.
Then Lordship may kindly have a look at the paragraph 6, my lord, for a moment. That with regard to the statement made in paragraph 14 of the writ petition, the deponent begged to state that temporary wooden bamboo bridges was constructed by the lessee with his own decision. There were no prior approval taken from the IWT Assam for constructing the bridges. As such, the claim of the petitioner for expenditure on the temporary bridges cannot be accepted. This is his prayer, my lord. His prayer is that he has constructed a wooden bridge, so department may compensate him, but he has not taken any prior approval from the department before constructing the wooden bridge, my lord.
So 4 kiss money, you have given him an extension.
Yes.
Yes,
only
Lordship,
4
paragraph 8, my lord. Regarding the
Okay.
statement 13, the petitioner begged to state that, the deponent begged to state that the office of the date so and so dated 28/12/2022, the petitioner was granted an extension of 1 month from time to deposit the 4th case money, my lord. It is annexed in our affidavit. This is page 46, annex 1, my lord.
Now let us see what is your ground for getting the remission.
My lord, kindly.
Where you have mentioned in your
Yes,
petition.
my lord. Kindly turn to annexure, my lord. This is first annexure. 8 and 9.
Now, where is your representation?
Yes, 2000 representation. Then lordship turn to page 38 annexure 10.
Huh?
It is, my lord, written by the address to the
The
assistant
petition has
executive
been
engineer by the
received from
executive
so and
engineer.
so who have been informed that farm huts which are within the jurisdiction of the state are being operated by municipality. Hence, you are requested to survey the and so. Now, what is your ground?
Ground, my lord, the two grounds, my lord, basically. my
Yes.
lord. One is, my lord, due to, my lord, the thinking of the water level, the ferry service between that, my lord, was not operating more than 15 days. That is, at the time of the filing, it is more than 1 month still up. Even then, more extended, another 1.5 months, that is totally unoperating.
So the water was less.
And the second ground is this, my lord, there's the four, my lord, the ferry services that is operated by the Jila Parishad, Gao Panchayat, and the, my lord, Anchalik
Were
Panchayat.
you not aware of that?
I am not aware about this.
No, no, were those ferry services running earlier?
No, yes, sir. I am coming to my lord.
Yeah.
I have given the reply to her. My,
No, no, I'm not, I'm only asking
no,
you.
it is all NITs were floated after NIT floated by the.
No, 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 no. Were there any ferry services running earlier also?
No, my lord, there was not there.
Are you saying on oath?
There's not there. Even then, my lord, the lordship, my lord, in our high court, in another judgment, they kindly turned to my affidavit reply. I have given an extra document, my lord.
Yes.
In my reply, that is filed on 21st/3/2023. It's the last annexer, annexer B that pays serial continuous pays 56. It is a similar instance, my lord, and our high court has given a pilot television on the ground of Mukalma ferry service, where also same thing was happened to that ferry service also. But the WPC number is, my lord, there is a mistake. It has to be 98. In the 2003 OM, my lord, it is specifically declared that the only water.
No, where have you mentioned in your petition about the water?
Yes, my lord. It is lordship will get a phrase. It is one of page 10, my lord. It started from para 9. It is after receiving of the kiss money and the kiss deposit from the petitioner number 1, the respondent number provided later is communicated on such and such requested the respondent number 2 hand over. Accordingly, we have done it. Then para 3:10, the petitioner back to state that thereafter the respondent number handed over the charges of the Budrusur ferry service towards the petitioner on 6/11, which the petitioner duly received and putting the signature, and accordingly from 6/1 he was in operation. And after taking over the charges, the Budrusur Water ferry services, the petitioner was running the ferry services with due satisfaction of the authority concerned. But after few days of the taking over the charges, the petitioner realized that the amount expected to be earned from the ferry services as per the day, on the basis of which he had participated in the tender process for settlement of the Budrusur Basantapur ferry services, were not into the mark of the satisfaction, and petitioner was compelled to run the ferry services in loss by incurring expenditure from his own pockets. And thereafter, the petitioner came to know that the reasons for his less collection of the freight from the said ferry services is due to the running of the another 4 ferry services on the basis of the settlement given by the Goalpara Jila Parishad, Matia Anchalik Panchayat, and the Budrusur block respectively, in violation of the provision of the Rule 35 of the Control and Management of the Ferries Rule 1968 and amended 1978-6. There, while the NIT of the 452 dated such and such was issued, respondent number 3, the settlement of the as many as 14 numbers of ferry services, including the Budrusur, that's serial number 2. The Matia Anchalik Panchayat, Goalpara Jila Parishad also floated an NIT under the Assam Panchayat Act for settlement of as many as 10 numbers of the ferry services.
No, no, but Mr. Mohanto,
My
is
lord.
this for the first time? These ferry services are running after your tender is over.
Yes, my tender.
Earlier, there was no.
No, man.
Where's your statement to this?
So that is why I have in my reply manner I have given, my lord. Yes, my reply that was filed on 31st May 2023, para 5. That in response to the environment made in the para 4 of the affidavit of opposition, the answering deponent denied the facts and further beg to state that the answering deponent came to know about the existence if the another 4 ferry services on the basis of the settlement given by the Gwalpara Gwalsar Jila Parishad, Mati Anchalik Panchayat and the Budusar Gaon Panchayat, respectively in favor of the concerned settlement.
Mr. Monsa, you have only stated that you came to know.
Yes, ma'am.
We are not on that.
My lord, even-
Whether there was a ferry service running prior to that. I'm
It was-
only putting you a specific question there.
It was not there, my lord, but the fact is that the NIT was floated after
No, no.
participation.
Are you saying that there cannot be any NIT? If there was all other NITs, you should have
No,
quoted
yes,
yes.
my lord, rule prevent that, my lord. Kindly come to rule, my lord. Rule 35, my lord.
Rule 35 says what?
Yes, but it specifically mentioned. If it is comes under 3.2 kilometer between my lord, the that existing ferry services, if the passenger ferry service cannot be operated except the passenger service, other things can be done. But this is all forms of the passenger service. So that cannot be done. And the High Court also, the rule by the notification OM 2003, it is specifically stated that the so far the ferry service between on the water, it is only with the settlement of the Inland Water Transport Department. No other have any authority. So this only that provision by the Honorable Court by in earlier judgment that is passed in WBC 6398 of 2017.
Where is that?
My lord, this communication has been.
No, no, not the communication.
I will, my lord, my lord, so that can be available, my lord.
Lordship, there is a OM of the government also, Lordship, I don't have this copy right now, but I can produce, my lord. That the other department have to take permission from the Inland Water Transport Department for floating of any ferry service tender. But in case I am not aware whether the Panchayat has taken any consent from the IWT or not.
No,
The Panchayat is
your
not-
affidavit, you categorically say that there were other ferry services which were running
My
at,
lord.
at the time when the tender was issued.
Yes,
Yes, my lord.
So he knew about these aspects.
This
of the matter.
aspect. Yes, my lord.
So he knew about
Knew
these
about the
aspects.
aspect.
So the question is that whether there was a permission being taken.
Yes, there is a different issue, but the construction of bridge, the
So
petitioner.
he's
has
not
to
saying anything about the construction of bridge.
the
You,
prayer
you don't
question.
want any amount for construction of bridge.
my lord.
Are you asking for construction of bridge?
My lord, whenever the communication between the two paragraphs is disrupted, then my lord, as per the rule 13, is my lord saying that this maintaining of all the approach route is to be with all the Inland Water Department. And we have my lord
No,
informed.
no. Have you informed?
Yes, I have informed my lord.
And did they allow you?
My lord, that is not. what-
No, 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 no. Did they allow you?
Yes, my lord, specifically on their report, my lord, it is specifically mentioned there.
Where
Can you
is
see,
it?
my lord?
Where did they allow?
My lord, the report, my lord, the annexure 11 at page 39, my lord. They never denied that I have not constructed incurring that amount, my lord.
Huh?
This is annexure 11 at page 39.
Yeah. Who has written this?
This is my lord, sectional officer.
What is this?
On the basis of the request made by the my lord, the executive engineer, he made the inquiry, my
I
lord.
have the
And that was
to
for
inform you
previous
that I have
session.
received an application from so and so. As per my report, most of the ghat points which are within the jurisdiction of so and so remand were giving settlement by Ansalik Panchayat. Hence, it is found the relativity of the they are losing some part of the revenue to settlement of different ghats by different government authorities. That is Ansalik Panchayat. And the water level have increased day by day that the time it can get made to put it for talking of the passenger cost of it. Therefore, I request you to take a step out the mention.
And that was done, my lord, in excess of the order given.
Who
by
is
the-
this sectional officer? Your person.
Yes, my
Yes,
lord,
my
they are
lord.
all here.
But we have not given approval to construct the wooden bridge, my lord. He have constructed by his own, my lord. He have not written to any letter to the department or the IWT director, my lord, to construct any bridge that he has suffered loss and he is going to construct any wooden bridge for transportation. He did not inform the IWT department, my lord. He built in his own. How
But the-
can we
But the
compensate
his
him?
officer, my lord, the executive engineer, he specifically admitted he thinks an annexure.
Is he a executive engineer, sectional officer?
No, no. The next page, my lord, this is annexure 12 at page 40, my lord. And that was done by in person of the executive engineer order, my lord. Section officer given the report, that was forwarded by the assistant executive engineer to the executive engineer. Then that was the observation, my lord.
In fact, executive engineer cannot approve to build a prudent bridge.
Approve is
Lordship.
a different thing, my lord. The fact remains is the
No.
same, my lord.
Here nothing has been stated that he have
And
given
even in, my lord,
approval.
the remuneration part that cannot deny, I am the order by the honorable court, by order, my lord, dated, my lord, this is on, 15. 28/4/2023, specific direction was given to them to take proper action to closing down the all port ferry services, which are running between the 3.2 kilometer of my ferry service. That was also
But
not,
madam, these are your officers
My
who
lord,
have written these letters.
but they have written, Lordship may kindly have a look, the fourth paragraph from below. That's the concern lessee has constructed, but he has not mentioned that he has
No,
taken.
forget about the breach.
My lord,
But about the
Yes.
other thing,
the remission part, Lordship may submit one thing, my lord. Lordship may remand the matter back to the director. He will examine all the aspects, whether it is within the distance of 3.2 kilometers or the other aspect, whether he has incurred any loss or anything else. And he will take a decision, my lord. This is a read code. How will they determine what is the distance between the two ferry services? This is my humble submission. Lordship may pass appropriate order. I have no objection, my lord. But
my lord,
regarding
my
the
lord, I have no objection, but the thing is, my lord, so far the my annexer by affidavit in reply that was filed in page number 56. Well, a similar order should be, my lord, they should observe, because in other cases, my lord, in the same circumstances, 4 ferry services that was run by the Panchayat. that-
why should I pass this order that it
Yeah.
pass a similar order like this?
No,
my lord may
not-
pass
I
appropriate
have no-
order.
Am I bound
They
by
should,
the,
my lord, they
No,
should.
my
Mr.
lord.
Monto, am I bound by the order passed
No,
by this
that's
director
not-
or whoever?
I
it
am
is?
not, my
Yes,
lord,
my lord.
my lord, putting any pressure on the lord.
Lordship may pass appropriate
The
order, my
director,
lord.
with it,
Yes.
whatever decision he takes, let him take on the basis of these two letters.
Yes, my lord, but the provision is, my lord, so far the rule is concerned, my lord, it is totally violated. So I claim for the remission. as per
Therefore,
the-
you are claiming remission.
Yes,
So
sir.
let the director take a call in view of these two letters,
my lord,
Annex 11.
Yes,
That's
my
not sitting, my lord, but
I think on the basis of 11 and 12, let the director take a call as to whether there has been a loss in view of there are various other
Ferry services.
Aspect.
ferry services.
My lord, Lordship.
So let them take a call on that
my lord.
and
no
whatever
objection.
may be the
My lord,
remission.
my fact is, I have been, my lord, depriving all the things, my lord, that is a genuine fact, whatever I have placed before a lawsuit. So that should be, my lord, sympathetically considered. That is all my prayer, my lord, because we are all the, my lord, unemployed youth, only just to, my lord.
Mr. Mohanta, don't you think that that particular submission you need to make before the director of
Yes,
ITP,
my lord.
No, my lord,
not before me?
no, my lord, lordship have the enough power, because, my lord, the lordship.
I don't
to
have the
see-
power for that to
Lord-
decide how
lordship-
much.
Lordship just have women, my lord, lordship to have a
But
look.
but what about the second part then? How can I dispose of with the second part
Which part, my lord?
as regards the extension of the kist and all?
My lord, if they are giving the remission, my lord, I will pay, my lord. Because my lord, without remission, it is an amount, my lord, 13 lakh something is comes. My lord, the amount is not, my lord, collected. This is the problem, my lord. So it is some, my lord, remission is given, then, my lord, I am able to operate, my lord. Otherwise, it is not possible, my lord. Because the amount, the base price is.
Madam, how much time would the director take?
To dispose of this representation.
No. To
Madam.
take a decision.
It is 1 month, Lordship.
No. Let us,
Then
we keep
15
this, we
to
keep
2
this
weeks, 2
matter
weeks.
pending.
My lord,
We'll have it after 15 days.
my lord,
I'll direct the director to take a call
My
on
lord.
his application for remission, taking into account Annex 11 and 12.
my lord,
And we keep the matter pending
Lord.
because your other aspect is there about the KISS money. So let us take a call. And in the meantime, if the director comes up any report and she submits a report on the next date, we take a call thereafter how to proceed. I think that is a better option.
my lord.
That will be-
Because if I do it, your other prayer becomes affected.
Yes, ma'am.
I think that is better off. Huh?
Most of it.
Lordship.
The learned counsel for the petitioner. Well, the case of the petitioner in the instant petition. Is that pursuant to NIT dated 28/6/2022, the settlement of Buduchor Bohantapur ferry service was settled with the petitioner by an order dated 27/9/2022. It further appears from a perusal of the petition that the petitioner thereupon initially deposited this money and the cash security on 5/11/2022. The first case,
My lord.
the first testament. Thereupon, on 6/11/2022, the Buduchor Bokhantapur ferry service was handed over to the petitioner by the respondent number 5. It is the case of the petitioner that after taking over the charge of Buduchur Bokhantapur ferry service, the petitioner started to run the ferry service with due satisfaction of the authority concerned. But after a few days of taking over the charge, the petitioner realized that the amount expected to be earned from the said ferry service per day, on the basis of which he had participated in the tender process for settlement of Buduchur Bokhantapur ferry service, were not into the mark of satisfaction, and the petitioner was compelled to run the ferry service in loss by incurring expenditure from his own pocket. And thereafter the petitioner came to know that the reason for less collection of freight from the said ferry service is due to running of another 4 ferry services on the basis of settlement given by the Goalpara Jila Parishad, Motia Anchalik Parishad and Buduchur block respectively, which was in violation to Rule 35 of the Control and Management of Ferries Rules 1968 as amended in 1976. The petitioner further, the further case of the petitioner is that the water level of the river Joljoli decreased day by day, and thereby the plying of boat was suspended on 20/11/2022. It is under such circumstances that the petitioner was compelled to build 2 foot bamboo/wooden bridges for crossing of the passengers at a cost of rupees 9,37,000. The petitioner thereupon submitted applications before the director. Did you submit it before the?
For the sectional officer initiative, that was forwarded to director. My lord.
Before the sectional officer Buduchur Bokhantapur ferry service for seeking remission, taking into account the losses which the petitioner incurred, as well as also on account of the expenditure incurred for construction of the foot bamboo/wooden bridge for crossing of the passengers. The learned counsel for the petitioner submits that these applications, though forwarded by the sectional officer Buduchur Bokhantapur ferry service, which was again forwarded by the assistant executive engineer, Inland Water Transport Subdivision, to the higher ups, thereby also conforming to the statements and conforming to the stand, thereby also vindicating the stand of the petitioner. The respondent director, IWC,
Yes, ma'am.
My lord, IWT.
IWT, have not taken any decision on the aspect of remission. The learned counsel for the petitioner further submitted that it is in view of no decision being taken on account of the remission. The petitioner is further handicapped in making payment of his regular kist amount. On the other hand, Ms. M. D. Bora, the learned counsel appearing on behalf of the Inland Water Transport Subdivision Department had submitted that at the time of the issuance of the NIT dated 28/6/2022, the other ferry services were running, which the petitioner duly knew and participated in the said NIT proceedings. She further submitted that as regards the construction of the wooden/bamboo bridges, the same were done by the petitioner without any concurrence or approval from the department. Full stop. This court, upon taking into consideration those aspects of the matter, more particularly taking into consideration the communications dated 13/12/2022 and 15/12/2022 issued by the sectional officer Buduchor Bokhantapur Ferry Service, as well as the assistant executive engineer Inland Water Transport Subdivisions, respectively, is of the opinion that it would be in the interest of justice that the director, IWT, takes a call as to whether the petitioner would be entitled to remission as well as reimbursement in respect to the would be entitled to remission as well as for reimbursement of the cost incurred in construction of the bamboo/wooden bridge. Under such circumstances, this court again fixes the matter on 11th of August 2023. The director of the Inland Water Transport Subdivision is therefore the Inland Water Transport Division Department is therefore directed to take into account the. You have submitted representation?
Yes.
Where is it dated?
There is a, this, I have an example.
Where?
It is
The
annex 9
sectional
and
officer, only that
8 and
representation.
9.
I'll-
This is 3/11/2022, my lord.
Where?
It is in page 36.
Tell
It's
you
even
will follow
36 and 37.
The representation submitted by the petitioner on 23/11/2022, along with
12/12/2022.
the communications dated 13/12/2022 and 15/12/2022 issued by the sectional officer Buduchur Bokhantapur Ferry Service and the assistant executive engineer Inland Water Transport Subdivision, respectively. Full stop. The petitioner is further given the liberty to submit a representation by Friday, by 21st, along with a certified copy of the incident order stating any additional fact if deemed necessary, if so advised. In addition to the representation so submitted on 23/11/2022. Full stop. The learned counsel appearing on behalf of the Inland Water Transport Department shall apprise this court on the next date, that is on 11th of August, as regards the fate of the representation submitted by the petitioner.
May
My
I
lord.
say 20, my lord?
Yes.
So for the, my lord, the director will take a call. So if reference to the, my lord, to rule 13 and 65, that I think will take.
What? That the kiss money.
No, my lord, it's a remission part and my lord, the provision is
will do as
34 and
well, lord.
35. That may be, my lord, mention like that.
Not necessary. You have
Yeah.
already mentioned
Yes, ma'am.
out there. I have asked you to give us additional representative. Why you are not giving?
Definitely I accept, my lord, but
I have given you everything you will
Deeply
give.
obliged, my lord.
We take a call later on.
Must.
If
Okay.
it comes before me again.
28 and 29.
Last of like.
Yes, what is this matter about?
Lordship, I am the owner of land 13 bigha in the area of Kanagar. Your Lordship will find page 22. The planning permit also has been granted to me.
Hmm.
Thereafter, my lord, thereafter they made a joint verification. That is page 26.
Hmm.
And joint verification, they have said close OE, date of issue patta 30 years old. In joint verification report, page close 4, date of issue of patta 30 years old. Yeah, my question is that when 30 years old land I am going to develop, forest department disturbing me. They made a joint verification along with the forest. And subsequently, one order has been passed, page 34.
No, Mr. Sharma, first tell me which repetition you are looking into.
282 parts.
Fantastic. 282.
Yes.
Both are the same person.
Same person.
Why there are two
Well,
repetitions?
because in the subsequent repetition, there are two plots of land, total land 38 bigha.
Okay.
In first plot, they have 13 bigha. And second plot, both the land clubbed together. Yellow, kindly page
Wait,
26.
issue a rule commanding to accept the joint verification report submitted upon joint intervention in the investigation conducted by the revenue department and park. Direction may be issued to division on the report of so and so. Okay, now tell me what are you asking for?
I'm asking for that letter dated page 30.
No, what is annexure page 17? Annexure 1 is the Jamabandi.
Yes, Lord.
Okay, Jamabandi in respect of whom? Sudha. Das. Now this land is how much?
Three Sudadas, Indodidas,
The
and
total is 13 bigha, 3 katha, 9.85 lechas.
yes.
Okay, then
Then our lordship will find the page 22. We have given a land development permit, planning permit.
in this matter, we are concerned about DAG number 1253.
Yes,
This is the land.
yes.
Okay, this has been certified by the. Yeah, then
Thereafter,
you have asked for
planning permit.
planning permit. What is this planning permit business?
Then we have to construct a wall and develop the land, dressing the land, etc.
Where is the GMDA?
GMDA is your lordship.
I know that. Where is that?
Your lordship will find the letter. Page 25.
Okay, then
Page 25 ADC letter to the circle officer, divisional forester, written to the circle officer. Regarding
including a
cutting
copy
of the
including
permission for art
connection with
cutting and
commission
dressing up.
dredging and of the Fatta land under 12.20. Therefore, request you kindly pick up the mutually convenient. Include the commission for cutting and dredging of Fatta. Okay, so now this divisional forest officer has also. This is a what type of land is this?
There
Hilly.
is a light hilly.
Ah.
And that's a earlier Guwahati nursery is there, my lord. They have planting nursery. Ramesh Sundardas initially, very big trees, mango, jackfruit, etc. Various trees and flowers. And it become hilly land. Bamboo is also there.
So
The forest department says that originally this land was USA under social forestry division. So they did not allow permission. Thereafter,
where is that?
there is a joint verification has been made.
Where did joint verification was carried out?
Carried out.
Okay.
After
Date of
joint
issue of the
verification, you
Fatta,
report your lordship.
30 years old.
Distance, page 27,
Now
distance.
you want this page 28 is your main document.
Page 28, yes, main document original, joint verification.
This has been signed by the revenue officer, then
Range officer,
range officer also.
yes, range officer also signed it.
Range officer is the forest department.
Yes,
Okay, now what is this document? Let us see. 1 to DAG number, Kiraj Patta number, new Patta number, 30 years old. Yes, up to date, continuous, about 40 years. No. Boundary, yes, about distance from the nearest areas, about 1 mile to the nearest. Kotanagar Are. 120 meters. Okay, then
thereafter, my lord, subsequently, all the developments, they have issued a letter, interdepartmental communication, page 34.
page 29 is what?
Page 29, your lordship. page 29, the letter regarding joint verification report and timber.
Was conducted in Iman and during the period of 67 numbers of raw wood trees found there and the state found Miyadi land as per raw record about 30 years ago and the land is one on the reserve forest. Then
After your lordship, one letter has been issued, page 33.
subject cancellation of Miyadi Patta and transfer and report.
The cancellation, the word cancellation art cutting, my lord, it should be.
No, huh?
It is vernacular art cutting. That the cancellation is mistake. my lord.
Okay.
The vernacular is art cutting.
Miyadi Mati, Pottar Mati, Porton Kuri, Pottanko Kora. Submission of enumeration list of trees. Then what happened?
Then after that page 34,
Yeah,
that is a problem for us. I'm reading your lordship.
that a survey was carried out at Bhutanagor using and at the year scheme and the owner of survey for the area of the land. And it was originally UTF as per the area and the no part of the okay, this one.
Yeah, yes, this one was communicated to Deputy Commissioner office. So Deputy Commissioner
No, what's the deputy? This is by the research education working plan to the principal chief conservator.
and communicated to the Deputy Commissioner Education, the Deputy Commissioner here.
Okay, then
Then Deputy Commissioner office keep silent. They did not give us any permission to construct and develop the land. They whenever I am going there to cut my land, forester come out.
what is this selling? Sell
This-
permission.
Yes, that is the WPC 20299,
Oh.
Buddha Bourbon case has said the land must be the forest land as per government record. But as per government record, it is not a forest
What is
land.
this selling? What is page 38?
Or state permission. yes,
Sell permission.
sale permission. Also granted. But
Huh?
we could not, also granted to me. But I could not execute the sale permission because of the letter dated page 34.
Right? Sell permission, why you could not?
Because they are not allowing us to execute the sale date,
Who?
the Deputy Commissioner office.
But this is being given by the deputy commissioner.
Deputy Commissioner office, my lord. This is the letter for the letter page 34.
No, page 34 is of 2017.
Yes, Lord.
Then in this sale permission was granted in 2022.
22. But
Then why?
they are keeping silent. They are not allowing to execute the sale permit.
Now you are appearing for whom?
I am appearing for the
Sudhadas.
Sudhara. Now, Lordship of the, they have misinterpreted the 2002 Buddha Bourbon case.
Now, Mr. Sharma, there was some litigation in that area, na? What is that litigation? There was some litigation on the forest. That is that area, the entire area, na?
Kalapahar area, man.
Kamakha
Kalapahar area.
No, this is the Kamakya area.
Not Kamakya area. This it is outside the purview of the Kamakya area. In that case, I was there in Guwahati High Court.
Oh, no, this is also Guwahati.
In Supreme Court of that's pending now, my lord.
Okay. It is pending where?
Yeah, it is regarding land in a division bench before this court. Single judge has disposed it. And it is pending before division bench. That
Ah.
covered only 5 villages: Kamakya village, Durga Sarovar village, and Bora and Bhubaneswari hill.
Ah.
And this Bhutanagar Nonke is not within that particular area. Kamakya area.
So this is out.
Out.
Now, DC, who is paying for DC? You are paying for, you are the revenue.
One thing
Who
I
is
like.
paying for the DC? Now, why after granting the permission, why you are not allowing the registration of the sale deed?
That I have to clear it up, my lord.
I'll talk to you
Yes, yes.
later on. Okay. How is it? This letter is of 2017. You gave a permission. Now this permission is in terms with 21A. Once 21A permission has been given, can the registering authority stop it?
Why, my lord, they have to stop, my lord, that's one I don't have now.
Was the matter filed yesterday?
But 23
The matter has been filed long time back, 2023 when? The notice was issued as far back as on 21/2023. Why you have no instructions?
Uh,
7 months have gone by. Okay, now, yes, now you wanted, you were anxious to say something. Tell me. Well,
Anxious matter. I'll take up 2998 matter.
Yeah.
Well, there's a report annexed, my lord. And one thing, my lord, it's not under social forest. It USF means unclassified state forest. It's letter at page 50.
yes. No, that is the letter which is there here also.
Yes, also. For my
Then-
convenience, I took up this pen.
Okay.
Page 50, my lord. MLC has substantial forest cover and it's original in USF.
Hmm.
USF doesn't mean, my lord, under social forestry. USF means unclassified state forest. And so, my lord, the Godavarman's case, which being, my lord, taken resorted to here, my lord. It's also mentioned, though I don't have a soft copy, the petitioner has mentioned at page 14 of the writ petition, my lord.
Hmm.
So it says, my lord, irrespective of ownership, if it in government records, if it's recorded as forest, then it is a forest. And when it's when it's classified as a forest, irrespective of ownership, my lord, this Forest Conservation Act comes in of 1980, which doesn't allow any non-forest activity. Non-forest activity means, my lord, activity which have been described here in below, my lord, in this act, my lord. So this
So
is,
you mean to say the nomenclature
my lord.
in the
Yes.
land?
Yes, my lord.
Let us see the nomenclature of the land here. It is already there in the Jamabandi. What is that? What is the nomenclature of the land?
It says, my lord, though
Are you
it's Herat
pouring?
Miadi.
No, it's saying foring.
Pouring.
Foring is not the forest.
That judgment says, my lord,
No, judgment will say, but the nomenclature of the land is foring.
pouring, my lord. That I got.
Yeah.
That
Then why are you saying it to be forest?
no, that in the teeth of the judgment, my lord, then in light of that Godavaram judgment, my lord,
Godavaram judgment will say that's on a different point. But where is in the revenue records it is being shown as forest?
my lord, revenue doesn't have these records because this record will pertain to forest only. If I can only produce the records, my lord,
Where is it?
that I have to bring it, my lord. I can bring it because it's recorded as a forest and also, my lord, in a very similar case as regards on Gitanagar Hill, my lord, this same provision was invoked and Gitanagar was protected, my lord, which said it's a deemed forest because of the forest cover on that hill, my lord. So, as regards that also, my lord, it's forest. Our records, my lord, it is reflected as unclassified state forest, my lord. If it is there, it is there. Either it's maybe if I can bring it, my lord, that's the case.
Why haven't you brought it?
My lord,
You were so anxious to make submission. Where is your document?
my lord.
Where is your document?
Well, I will need some time, man.
Why?
Some time
Is that
at least.
2023 matter? January 2023.
No, my lord, because I had assured him that we are not doing anything harmful. We are not resorting to
happy
course
with it?
action.
Your lordship,
No, Mr. Sharma, you are happy with it?
no. I am saying that what he is saying, the Forest Conservation Act came into existence 1980. My land has been mutated in my land 1973. The Forest Conservation Act not apply. I got a similar decision in Odisha case, my lord. In this regard, Forest Conservation Act came into 1980. The my has been settlement is a Miyadi Patka land in my name in 1973. That is page 24.
Leaving aside
Anyways,
conservation
we give
act,
him one chance.
my lord.
Why didn't you make that submission before? Instead of spoiling the time of this court? Okay, Mr. D. Gogoi, the Learned Counsel appearing on behalf of the Forest Department submits that he would like affidavit? No affidavit.
Instructions. my lord.
No,
Affidavit
that's the
submitted.
instruction submits that he would like to take, he submits that he would like to produce the records
Yes.
pertaining to, where is the document? But produce the record on the basis of which the communication dated 1st of September 2017 was issued by the additional PCCF Research, Education and Working Plans Assam. When?
After 10 days,
Okay, list the matter again on 28th of July, 2023,
Well-
on which date he shall produce the records as well as the instructions in the matter in respect to both the writ petitions.
Very good. Already.
Mr. J. Hendig, appearing on behalf of the Deputy Commissioner, shall also apprise this court as to on what basis the registering authority have refused to register the deed of sale in spite of the permission having been granted on, what is the date? Two seven 2022.
Always, man.
At number 30.
Wait, your lordship. Madam, today I have filed the affidavit, my lord.
Okay, Ms. M. D. Bora, the learned counsel appearing on behalf of the petitioner submits that the affidavit in opposition has been filed on behalf of the IWT department.
Right.
And however, the same is not on record. List the matter again on 9th of August 2023, along with the said affidavit in opposition filed by the IWT. The petitioner, if so advised, is at liberty to file their reply.
Deeply obliged.
31.
In this matter, I have filed my affidavit.
Affidavit has come now. Okay, none appears on behalf of the petitioner on call. Ms. M. D. Bora, appearing on behalf of the Transport Department, has submitted that the affidavit has already been filed on 19/6/2023.
But no reply has been filed by the
What is this matter about?
regarding matlab, lordship, it's impose a fine, my lord, for over speeding. In fact, right order dated 1/2/2023,
Overspeeding?
my lord.
Where?
Lordship may kindly have a look the order dated 1/2/2023. This honorable court has directed the petitioner to deposit the fine, my lord.
How much is the fine?
2,000, my lord.
Very well, something must be very serious. Okay. Okay.
Direction to pay the fine,
Oh, this one.
my lord.
Oh. Taking into account that the matter would require a deep hearing into the matter, taking into account the above. No, here goes Ms. M. D. Bora, the learned counsel appearing on behalf of the Transport Department has submitted that the affidavit has already been filed. Taking into account the issue involved, lists the matter for hearing and the issue rule reads the matter for hearing after the October vacations.
I'm deeply obliged, my lord.
In the month of November.
32.
Where please the lordship kindly mention in the Passover code.
Huh?
Passover code.
Yes, Mr. You have instruction, no instruction.
Well, this can be disposed of.
Yes, what is it?
Well, this is something regarding my lord, contractor's bill, my lord. A part of it has been deducted as a forest royalty because he was not able to show the source. So, my lord, my submission was if he can produce the vouchers of the royalty paid sources, we can verify and close it up. He's from Kachar, my lord. He was awarded a contract and he procured some materials from Mizoram, he says.
So you have retained 30 lakhs.
Not asked, my lord.
It is observed that the pendency of the request shall not be barred for a respondent to consider the matter of forest royalty against which a sum of rupees 30 lakhs have been retained.
My lord.
So you are willing to give, provided he produces the voucher.
He produces the vouchers, shows the origin, shows that you have paid royalty to the articles which have you used. Take off your payment and go.
Yes, madam.
I have been told, my lord, the petitioner counsel, his mother is sick, my lord.
Okay.
Lordship will take note of
The
one.
counsel appearing on behalf of the,
Lordship will take note of one paragraph in page at page 40, Lordship.
yes,
This is a letter written by the executive engineer to the empowered officer, Lordship. Dear Lordship, one paragraph is there. A letter was forwarded to the DFO, Lordship. In reply, the DFO Hailakandi has informed this office that
The extraction of mine or minerals for the above mentioned work by the contractor Sri Raju Chaudhary is illegal and violation of contract agreement.
In reply, the DFO Hailakandi has informed this office that extraction of minor minerals from the above mentioned work by the contractor so and so is illegal and violation of it, and asks to recover the FR so and so. So this is what has been mentioned out there, but they are willing to give him. If their basic stand is that once they show that they have paid the royalty out there, they will.
That is their lordship. That they have, the payment certificate is there.
No, we won't, they cause any further problem as the mother is sick. It won't be proper. Okay. The learned counsel appearing on behalf of the petitioner seeks for an accommodation as the arguing counsel is indisposed due to personal reasons. List the matter again on 26th of July.
Oh, let's.
33,
Meet it.
Yes, Mr. Brown.
My lord. Petitioner is a small time businessman, my lord. He collects human hair, rotten human hair, and then he sells it within the state. He is he has a registered farm in the name of Indian Hair in Moradabad, Calcutta. And then, my lord, he sent one consignment in May 22, 16 bags of damaged hair, and the weight is about 356 kg, and that has been retained or seized by the.
Yes, madam, what do you have to say?
Lordship, my senior is on leg with another phone. He will come in between.
Okay. You have filed your affidavit.
Yes, my lord, they have filed, and they have accepted that we have given all the documents they wanted from us. They have examined here in Guwahati Custom Office, then send it back to Calcutta. Calcutta also satisfied with that. After that, my lord, normally they should have passed the order, but that has not been come after. This is about more than 1 year has been elapsed.
So you want them to pass the order?
That we have earlier, this court has said that penalty of this
Not to give it to third party.
Yeah. So then we have also filed a petition to release it to us under section 110 capital A, where it is they can give interim position of the thing.
You have done it there.
There.
Then
They have not done anything till 1 year. So now, my lord, the hair that we have collected is a perishable good in the sense, my lord, if it is kept without spraying certain medicine there, some insect will enter and the whole lot will be damaged.
so you want them to pass the order as soon as possible.
My lord.
To being a finality to the whatever it is.
Yes, my lord.
But here the prayer is otherwise for release. You are asking the final release prayer here, where the authorities are now presently taking up the matter. Where is your senior? When is he coming?
My lord, if your lordship please, I have made a small, my lord.
Mr. Burangway, we'll do one thing, we'll take it up at 2. Ask your senior to be present or get his instruction, we dispose it of. These matters can't be kept pending. Perishable goods.
34,
34 lordship, we are going to file an affidavit today.
Mr. J. Hendig appearing on behalf of
My lord, the deputy
Yeah.
commissioner.
Get a part, Miller,
Yes, 1
before he submits Miller, he has
Ah.
to call parental justice and submitting this. NSA is made party here. National Highway Authority of India as a requiring party of the land. But my instruction is that this particular area where road is being constructed, is not by the National Highway Authority. Now my learned friend is to verify who is the constructing agency, then only because.
But this is a land acquisition.
Yes, payment of compensation
Now,
regarding.
who is acquiring the land? That I think you should be knowing.
For whom they are going to.
Who is the requiring authority?
DC, my lord.
Deputy Commissioner.
No, that is acquiring.
Deputy is the acquiring authority. Who is the requiring authority?
Requiring to, sir. Otherwise, it will be keep on leading.
Hmm.
Otherwise, again, problem will come. That's why.
For what purpose the land has been taken?
My lord, for proposed bypass land national highway, my lord.
By whom? That is only who is the constructing agent.
Where is the section 4, section 11? This is done under the new act? Or this is under the, where is that notification?
So this is nothing is there, my lord. There is the problems are coming up.
And you have filed a petition, affidavit, you don't know. Oh, Mr. Hendrik,
Lordship, my lord, that it was earlier, my lord, required some other council, my lord. He told me that, my lord, there he is going to file an affidavit.
Mr. Hendrik, kindly don't make that. Yesterday, there was one matter where one council was appearing on behalf of some other council and said that I want the writ petition to be disposed of as infructuous. Later on, I come to know when the actual council comes that he has a serious prayer in the writ petition. This is the state of affairs. But as per you, Mr. Borua, it is not NHA.
NSA, that is NSA. Now I cannot verify because there is an agency and PW NSDB also construct national highway.
But it is not under NHA.
That is not under NSA. That is, I'm sure, because instruction is for me. And this regard, I wanted to file also affidavit to that effect. So that
Okay, you file your affidavit.
that effect I have already sent. Now likely to file.
My lord,
Mr. C. Borua, the council appearing on behalf of the respondent
number
number,
Four, my lord.
respondent number 4, I submitted that as per his instruction,
Yes.
the land has not, the instruction, the National Highway Authority of India is not the requiring authority in
That's
respect to the acquisition proceeding. Mr. J. Hendik, the learned counsel appearing on behalf of the respondent number 2 and 3, however, is not aware as to why the, for whom, appearing on behalf of the respondent number 2, who is the acquiring authority, is not aware as to who is the requiring authority. Mr. Datta, you are aware? Mr. S. Datta, the learned counsel appearing on behalf of the Revenue Department, is also not aware as to for whom the land has been acquired. Full stop. Taking into account the above list matter again on 26th of on 2nd of August 2023, on which date the learned counsel appearing on behalf of the respondent number 2123 shall apprise this court as to for who is the requiring authority for whom the land has been acquired. Mr. C. Borua, the learned counsel appearing on behalf of the respondent number 4, is also at liberty to bring on record by way of an affidavit their stand that they are not the requiring authority.
My lord.
my lord, I pray for my imprimatur because my lord, construction is going on over my land, my lord. So without any, my lord, acquisition proceeding.
There is no acquisition proceeding.
My lord,
No.
yes, my lord, that is why, my lord, one acquisition proceeding is there. My land out of 5 bigger, then only 1 bigger 2 cutters are acquired, and that for that part I have compensated, my lord. I have taken that position, but they have taken extra 4 biggers, my lord. That is my case. Extra 4 biggers of land, my lord. Only they have taken, my lord, 1 bigger 7 less as per acquisition proceeding, my lord, and they are now they come. I take possession 4 biggers extra, 4 bigger, my lord. That is the question. Now construction is going on. And that is why I have not challenged the acquisition proceeding. I praise for compensation. If the land is required, then I have no objection. So I require compensation. But without giving any compensation, they are going away.
Mr. So-and-so, your name?
M. Hussain.
M. Hussain, the learned counsel appearing on behalf of the petitioner, submits that although the acquisition authority have acquired 1 bigger of land of the petitioner, however,
1 bigger 7 lesser.
1 bigger 7 lecha of land. However,
Out of
in addition to that, another 4 bighas of land
4 bigger 1 kata 13 lesser.
have been, but however, in addition to that, another 4 bigha, 1 kata 13 lecha of land, the possession of the of land, the possession of 4 bigha, 1 kata 13 lecha was taken away from the petitioner. Was- এই লাইনটো এইটো গুচাই দিম। এনেকে লিখ। Mr. M. Hussain, the learned counsel appearing on behalf of the petitioner submits that the petitioner is aggrieved by the actions of the respondent authority in taking over possession of an area of land measuring 4 bigha, 1 katha, 13 lecha, which have not been acquired. Mr. C. Borua, appearing on behalf of the respondent number 4, submits that the land has not been acquired at the instance of the respondent number 4. The counsels appearing on behalf of the respondent number 1, 2, and 3 have no instructions as to for whom the land has been acquired. Their said counsels are also have no instructions in the matter. Taking into account the above, let the matter be listed again on 26th of July 2023, on which date the learned counsel Mr. S. Dutta and Mr. J. Hendrick, appearing on behalf of the respondent number 1 and respondent number 2 and 3 respectively, shall obtain the necessary instructions in that regard.
Without other, if my lord, subsequently, if land is not required by any department, then my cultivable land, my lord, all will be disturbed, my lord. If they had put my
Mr. Counsel, I have not disposed of the matter.
obliged, my lord. Pardon.
I am presently sitting for 2 weeks.
Right.
So it is there. I'm taking up this matter next week also.
Highly,
So I'll take care of it.
highly.
Timing item 33.
My lord, may I
Yes,
take
Mr.
your-
Kyle, in this matter, why haven't you passed an order?
No, Lordship, in this case, his application for provisional release was rejected. Thereafter, notice under section 124 has been issued on 22nd of May. And that is mandatory, and under before confiscation, the notice is required to be issued. And he has failed to prove his ownership, Lordship. That's why it was not released to him.
Have you passed any order?
Yes, Lord.
Where?
Lordship, in affidavit, we have subsequently it was passed. For provisional release, that was rejected.
That was okay, but what about the main thing?
Lordship, that notice under section 144, 124 has been issued.
Then?
Then there will be adjudication. He has to reply.
Has you received the
That's,
124?
Lordship, on 22nd May, it was issued to the petitioner.
That is one point, my lord, he had said just now. But the main thing is that they cannot, under the law, they cannot confiscate any other matter which is inside India, moving inside India, and only coming imported things they can confiscate. Here, your lordship, your lordship, I will go to this point, 111. This is under this chapter, my lord, chapter 14, they cannot confiscate any material, particularly human hair, which is a free material. It is not a contraband or a matter which is prohibited. It is only make a restricted item by his own affidavit. I have seen it from 25/1/2022, and restricted. What is restricted is not mentioned here, and that is also not clarified, or definition has not been given on the restriction. Now your lordship will see whatever he has said, they have no power to confiscate any matter which is within the state. So this, my
You are
lord,
you are referring
16
to which, where, you are referring
this
to,
one, my lord. Your lordship will.
what is that?
This is the
Act of what?
Customs Act.
Customs Technology?
May I read that, my lord?
Hmm.
The cast 124 issue of so-called notice before confiscation of goods, and this is under the chapter 10 plus 14, which says then confiscation of goods and conveyance and imposition of penalties, confiscation of improperly imported goods. It is not an imported good, my lord. Your lordship will first go to para 5, page 6. It is only I collect it from house to house, then send it and sell locally inside India for making wigs and hair for the women folk. We have booked 16 bags of damaged hair in Sialdah railway station, Calcutta, through my booking agent, Mahakali Enterprise, sister concern of Srishti Enterprise. After and we have given all the documents that the custom department has.
When did this happen?
It was happened, my lord, 27 May 22. It is now, my lord, 1 year.
So as of now, it is restricted.
Yes, it is restricted.
It is restricted.
It is restricted.
But this is restricted from the point of commerce, Ministry of Commerce.
No, it is also not a material which cannot be exported. Restricted means we will have to give the details where from we have procured it, and then we can export it. It is, and our case is also not that we are going to export it. Our case is that we have procured it in Calcutta. Then there is a partisan in Guwahati. We have booked it in the train from my agent, and it came to Guwahati. In Guwahati, my agent immediately could not take it on 27th. So it was under the custody of the railways. It ought to have been in the railway godown. But however, they say that it was in the platform. So the custom officers has come there and seized there. So thereafter they have filed what your notification to us. Say that if you are on the basis of the address we have given on the particular packets. So we have received it, and your lordship will get the notification at page 30 given by the custom department. Under section 108 of the Customs Act. So this is Kitab Ali is my name, and my farm name is Indian Hair. Whereas I should visit day and making inquiry in connection with customs case number so and so, dated 27/5/22 under the Custom Act 62. And whereas I consider your attendance, give evidence, and to produce documents for things of the following description in possession and under your control. All relevant documents in respect of the above case. So that's the one. Next page, my lord. This is from Guwahati Custom Office. And as I have already said that the Calcutta Custom Office also given us notice. I so and so making inquiry in the connection of against seizure of 16 numbers of bags so and so dated 27/5 under the Customs Act 1962. And whereas I consider your attendance, give evidence, produce documents or things that of the following descriptions in your possession: your identity proof, detailed information in respect of the origin, owner, transportation, receiver of the goods, and then other relevant document. Then your lordship will kindly go to page number 1, page number 16. The documents which they required, we have placed before them. This is, my lord, trade registration certificate number 14HC. Your lordship has found it. Form number 11.
Yes.
Yes. This is Mohammed Kitab Ali. I trade in human hair, description of trade, human hair. So this is the trade license I have given by the authority concerned. On the basis of this, my lord, next is the I'm income tax SSC, and I have paid income tax return for the year 222.
So did you pay GST also?
Yes, my lord. That is what they have said, that I have not paid GST. And straight, your lordship can go to page 33. That is the GST for this particular GST at page 33. History Enterprise, this is the person, transport agency through whom I have paid. Above that, my lord, your lordship will find GST in deal. Small letters, my lord. It is visible to your lordship. GST in deal. Your lordship has found it. Then serial number, such and such, left hand side, my lord.
Yes, Mr. Kyle, what is your
Then
business
16 number 6.
of doing it? You are customs?
Yes, Lordship, may please to come to page 35, the part of my affidavit, Lordship.
35, yes.
The facts of the case, Lord.
Ah.
That on 27/5/22, the officer
No,
of
that is okay, but tell me where do you get the power to do so? The
Lordship-
customs, what power does it have?
Lordship, what happened in this case, the goods were booked through railway and they were found to be unclaimed. Then the railway informed the custom officer. Then they come there. And since the goods were restricted, so they took in position, and in the meantime, Lordship, many people came to the office of the custom to take possession of the goods. But when they were asked to produce the proof as ownership, document related to their proof of ownership, everybody failed. Then notice was issued to the present petitioner, Lordship. He also failed to produce all the documents. Lordship, may please to see. He was asked to produce the document. Lordship, page 37, Lord, paragraph I.
Yes.
That the addressee along with the trade license and GST registration of Kitab Ali and human hair has been verified. Though the Kitab Ali admitted in his statement that it turned so that the supply of the human hair which was seized in the case was made by him, but he failed to produce any GST invoice in support of his claim regarding ownership of the seized goods. He only produced a road challan issued in the name of Babul Sarkar. And Lordship, may please to see.
But what is this document at page 56?
Lordship, page 56 is the invoice, copy of invoice which was annexed by the petitioner in his end, but he has failed to annex page 55, Lordship. This was another.
No, that is okay. That is
And the-
Babul. No, this is the transport agent. I'm not concerned. But what do you say about page 56?
Lordship, page 56 is there is a contradiction between two invoices. Here, Lordship, amount is 11,000 to 14, whereas the value of the goods declared was 16,70,600.
No, it is there. Human hair total value is given out there. See,
Lordship,
at page 56.
11,200.
No. That is the tax. Kindly see the human hair. The total value of it.
Lordship, total rate, total value 10,618, Lordship.
No. Total human hair total value is 16,37,600.
Yes, sir, Lordship.
Then what is your business of doing all these things? When you are releasing it?
And Lordship, another thing, since
Yes.
the goods are restricted, and Lordship, we have made a statement category.
No, restricted, okay. But if it is done in because here you see there is no IGST involved.
No, Lordship, please to see. Lordship, page 35, last 6 lines. It's the owner of the said 16 numbers of SDFC bag containing human hair did not turn up, though the officer waited for sufficient time. As per the intelligence, 16 numbers of SDFC bags containing human hair had been brought to Guwahati or onward transportation to Imphal. And same would be finally further illegally exported to Myanmar via More. The custom officer therefore formed a reasonable belief that the goods are liable to be confiscated under section 113B of the.
No,
Custom
what
Act.
is your basis on which you formed this opinion
No.
that it will go to More?
Now, there was a intelligence information also.
Where is it?
I can produce the record of it if you
When?
like tomorrow.
Okay. We'll have it tomorrow, day after, at 10:30.
Lots.
The learned counsel appearing on behalf of the customs, Mr. S.C. Kyle appearing on behalf of the customs shall produce the basis on which the
16
basis on which the custom officer had formed the reasonable belief that the goods, which is 16 numbers of HDPE bags containing human hair, were for onward transportation to Imphal and would be further illegally exported to Myanmar via More.
Yeah.
The matter would be taken up at 10:30.
Chapter tomorrow. Acha.
Request take the list on 21 and taken up at 10.
Lots.
Timing item 1.
They have taken steps. The learned counsel appearing on behalf of the petitioner has already taken steps upon the respondent numbers
6, 7 and 9.
6, 7 and 9. 6, 7 and 9 by way of registered post as well as usual.
We just registered post lordship.
Why not the usual?
Lordship, I've sent for that lordship. That'll take some time.
Huh?
I've gone for registered post lordship. The second one is being taken right now.
The learned counsel appearing on behalf of the petitioner submits that steps by way of registered post have already been taken upon the respondent number 6, 7 and 9. So as regards the usual process, the steps are being currently taken and which will be completed during the course of the day. List the matter after completion of service. List the matter after effecting service upon the concerned respondent.
35.
Yes.
May I please the lordship? In this case, lordship, earlier code period was expired on 6/5/2020 by operation of law, and according one-man committee was appointed, and under the one-man committee, the election was held on 18/3/2023, and accordingly it was proceeding on February before the register for approval. But due to a complaint filed by the respondent number 6, the proceeding was disapproved without hearing the present petitioner. They have already been elected and winning certificate is provided. Your lordship will find the complaint impunity is page 44. 84.
Page
84.
Hey,
The allegation, my senior.
yes,
The whole question about this one committee, one man committee, it was expired by around on 6/5/22. Thereafter, mother, that, so the idea committee, the one committee was formed, one man committee. One man committee issued notice, correction about voter list, date of election. Initially, date was given on 11, quorum was not fulfilled. Subsequently, it was fixed on 18, quorum was fulfilled. Then in that case, mother, total out of 17, 14 persons, mother, they are the applicant. So it is less than that, so they have been declared to be elected. They got the winning certificate also. Thereafter, my lord, this impunity order has come. This, your lordship has seen. One
Mr.
person,
Chaudhary, who are you?
I am the idea who has been elected now as the president, chairman.
All of you have been elected
Yes,
as,
yeah, all of us elected,
as board of directors,
board of directors.
all of you,
Yes, man, all of them.
and none of you were heard.
No, none of them. It's order itself shows, my.
That instruction, my lord, is sought for. Whether
Well,
apparently
why
from
did
the
it
order
take such
it
a long
appears, my
time?
lord.
What?
From the order it appears, my lord, they were
Order.
not heard because it's not integrated.
No, they have already put the names out there who have been
Yes,
heard.
yes, my lord, yes.
Then-
My lord, it may be relegated, affording them the opportunity to participate. My lord, it may be heard afresh. If that be so, my lord, this order cannot sustain.
But in the meantime, we already winning certificate we got, man.
No, my lord,
Yeah, let it
Yes,
be
my lord.
done within 15 days.
yes, yes, correct.
Heard Mr. H.R. Chaudhary, the learned city. Yeah. The case of the petitioner hearing. The case of the petitioner hearing. The petitioners hearing who were elected to the board. You were elected to the board.
Yes.
The
Unappointed,
board-
my lord.
To
Yes.
the board of the, which cooperative society?
It is this total, my
Of
lord.
Meherpur
Meherpur, Krishnapur.
Krishnapur CS
Yeah.
Limited. In the AGM held on 18/3/2023 are aggrieved by the order dated 3rd of April 2023, whereby the Register of Cooperative Society Assam had disapproved the election held on 18/3/2023 on the grounds and reasons stated therein. The learned counsel appearing on behalf of the petitioner submit that a perusal of the order dated 3rd of April 2023 impugned in the instant proceedings clearly shows that the Register of Cooperative Society have only heard the persons whose names have appeared at serial number 1 to 4 in the order dated 3rd of April 2001 to 4 have only heard the persons whose names have been mentioned at serial number 1 to 4 of the order dated 3rd of April 2023. The petitioner's rights have been violated in as much as the said order has been passed without giving the petitioner an opportunity of hearing. Mr. S.K. Talukdar, the learned counsel appearing on behalf of the Corporation Department. You're back again.
My lord,
You're back again.
no, I'm there, my lord.
No, you were not there for the time with some period.
No, I'm continuing.
And now you're again.
For all.
Alternative to him.
Or is it in only in bench 4 you are continuing?
No, I've been there.
Mr. S.K. Talukdar, the learned counsel appearing on behalf of the Corporation Department, fairly submits that from a perusal of the impugned order dated 3rd of April 2023.
Well, lordship will only indicate that instruction is sought for. That is, my lord, that has not come. But from here
It is what I am saying.
My lord.
fairly submit that from a perusal of the order dated 3rd of April 2023 issued by impugn order dated 3rd of April 2023, it does not reflect that the petitioners who have been affected by the say decision were heard. He submits that taking into account that the said aspect of the matter, he therefore submits that as the issue involved therein would involve taking into account minute details as regards various aspects of the matter, and the register of cooperative society would be in a position to decide the same by giving an opportunity of hearing to the petitioner. The matter may be relegated back to the Register of Cooperative Society, Assam, for a fresh decision. Upon hearing the learned counsels for the parties and taking into account that from a perusal of the impugn order dated 3rd of April 2023, it does not reflect that the petitioners were heard, although the order so passed was affecting the rights of the petitioner. This court therefore sets aside the order dated 3rd of April 2023. This court further is of the opinion that is also of the opinion that the complaints were submitted by, you are there?
Yes, I have responded to a 6 complainant matter.
By the respondent number 6 also needs to be adjudicated upon. Accordingly, this court therefore directs the Register of Cooperative Society to take a decision in respect to the complaint so filed on, when did you file?
My lord, two complaints filed, my lord.
On the complaint so filed by the respondent number 6 within a period of how much?
Short. My lord, he's in the charge of other department also, so 1 month will be reasonable, my lord, I think.
Within a period of 1 month from today.
Today, man, today.
Within a period of 1 month from today. Full stop. A copy of the instant order be served upon Mr. S.K. Talukdar, the learned counsel, appearing on behalf of the Corporation Department to intimate the Register of Cooperative Society about the order so passed and for effectual compliance.
That's only one observation.
Yeah.
Your lordship has not expressed anything on merit, and this order will
It
not
is made
influence.
clear that this court have set aside the order dated 3/4/2023 only on the ground of violation of the principles of natural justice, in as much as the petitioner were not heard. Full stop. This court, however, have not dealt with the merit of the said merit of the dispute involved in the complaint. Filed by the respondent.
Apply you.
Thirty-six.
36 lordships, I pray for some time, lordship. Item 36 and item 59 of the supplementary list. The issue is same, relates to physical position to be taken by the bank, my lord, and under the SARFAESI Act. And my lord, they may be taken up together. Also.
Why are you making these people a party? What is this matter about?
My lord, these, as far as 36 is concerned, my lord, we filed an application, my lord, under the section 14 of the SARFAESI Act, taking physical possession of a property. The property has been sold, my lord, sale certificate has been issued. And in fact, my lord, in this case, an application was filed way back in 2022. My lord. We have annexed the application. Some queries were asked for by the office of the deputy commissioner. We have responded to them. Now, there is no stay order from any court, my lord. Supreme Court, my lord, in a catena of judgment has held that time, my lord, this is a ministerial function. There is no purpose of any hearing and he has to only pass a ministerial order that, all right, I am satisfied, and the date has to be fixed for taking the possession. In fact, in the other item, item 59, there is a order of the deputy commissioner, and an attempt was made to take the possession also. For whatever reasons, my lord, for which we are not aware, the position was deferred. Now, these are cases where, my lord,
No, who is HM Construct?
HM Construction is the borrower, my lord. And my lord, they mortgage the property in question. My lord, as far as these people are concerned, my lord, they are not easy because they had filed an essay also before the DRT, that Guwahati. They have annexed the order, they did not perceive it, that the essay was dismissed for non-prosecution. So as of today, my lord, there is no impediment to the deputy commissioner passing an order for taking physical position. And in case he decides to withdraw, reject our application, let him pass an order.
What about the Justice Patnaik's judgment in that surfacing matter, wherein it says that the possession which is to be taken under section 14, it will be given under to the TS. The district magistrate has to decide that aspect of the matter. And
No, but my lord, there are subsequent judgments of my lord, the Supreme Court as recent as 2022 also, in which it has been held that it is a ministerial function, my lord, and my lord, the Supreme Court has gone so far as
so
to
how
hold
many
that-
judges? Because that was a 3 judge.
my lord, I think whatever is to be judgment or
So that's a 3 judge.
but all subsequent judgments and recently Justice M.R. Shah judgment also repeatedly it has been held that, my lord, it's a ministerial function. Time is of the offense, and my lord, no delay is to be proved. In fact, these are so much the word.
No, understood.
Sure.
But I'm not saying that it is not a ministerial function,
Sure.
but there is an objection to which can be filed by those persons concerned.
Well, in that case, my lord, he would have to, he has to do something, my lord. He has to either issue notice, in which case, my lord, we have answered whatever.
No, he has the borrower has an option, or in third party has an option.
Actually, borrower, as on day the law says, the borrower has no option. The borrower, my lord, even if.
No. A third party has an option. As per Justice Patnaik judgment.
But here there is no third party involved. The only third party involved is the auction purchaser. He has put in his hard-earned money. He has got the sale certificate. And lordships are aware that after the.
So under such circumstances, here they have to do it.
They have to do it.
Who is paying for the third party? That the borrower.
Because borrower was not issued notice because it's not required.
But why have you made him a party?
But Justice Surana's order is there. I think the notice was not necessary at that point.
But why have you made him a party?
Struck off. Struck off.
You struck off.
No, he can be struck off. He was struck off.
You can't struck off like this now. Nowadays you have to remove him.
There is an order, I believe, that of Justice Surana that they would be struck off.
Notice that the paper, the names of the year are struck off without altering the period of the. But this needs to be changed now. Then under such circumstances, what is this affidavit business now? Why you are not taking steps? It is a statutory duty you have to comply with.
That instruction, my lord.
What instructions?
My lord, that what step they
Okay,
have taken.
we'll have it on Monday. Get your instructions.
But can a similar order be, can the other matter be also taken up on Monday?
Same matter.
Well, petition is a different issue is same, section 14.
So we'll take it up on Monday. Both 59 years. The Learned Counsel, Mr. J. Hendrick, the Learned Counsel, appearing on behalf of the petitioner, on behalf of the Deputy Commissioner, shall apprise this court as to why no action has been taken pursuant to the application filed by the petitioner for in terms with section 14 of the Surface Act.
Lordship, my lord, kindly see the election 7, page 25. My lord, there is no date. When the my lord, that application has been submitted before the deputy commissioner.
Yes, why have no date?
Nothing, lordship.
I am told that the date is in there was some other documents in which the date is there. But my lord, that is not the issue.
Okay, you get your instruction. If there is no application filed, we'll take
fact,
it up.
your
Then we'll
personal-
ask them to file a fresh application and let the law take its own course.
Look, in both the cases, Justice Surana has directed us to furnish the certified copies of the orders. We have done that. That is also my lord there. Both the in both the cases. So they are fully aware.
Let them be fully aware, but there is no date. If nothing happens, we'll take it up on 24th. We'll dispose it of.
Lovely. So both to be taken.
59. Same order date. Electrically. The J. Hendrick appearing on behalf of the Deputy Commissioner, which we would speak.
Kamrup Metro.
Kamrup Metro. shall apprise this court as to why no steps have been taken pursuant to the application filed under section 14 of the Surface Act by the petitioner.
Supplementary list, I don't know, 55.
Meet the lord.
You gotta stay on the bank guarantee.
Yes, sir.
Very well. What is the basis?
Basis is, my lord, the respondent FCI want to invoke a bank guarantee in respect of a different contract, my lord, as a penal consequences without issuing notice to us. That contract has already been discharged, my lord. And, my lord, in fact, their affidavit shows, my lord, in respect of the other contract, my lord, some factual background is there, my lord. How this penalty has to be imposed, my lord. What has happened, my lord? The petitioner herein participated in a joint venture tender of railway, my lord. There, my lord, the other venture bidder, they could not submit the earnest money deposit at that relevant point of time. And because of that, the contract was terminated and the EMD was forfeited because further security was not deposited. The petitioner here is primarily a FCI contractor, my lord. He had participated in other tenders, my lord. One of his competitor, my lord, he complained to the FCI authorities, stating that since there is a clause in the tender that if tenders are for, if contracts of other agencies are terminated or EMD is forfeited, then it becomes a disqualification.
Then it requires your disclosure.
For not giving a candid disclosure.
And there is no disclosure.
No disclosure.
And for which it has been terminated.
Yes.
Now they want to invoke the bank guarantee.
Now, in between what has happened, that the bank guarantee relates to a period prior to these events, Lord, for which I have already awarded a contract in 2018, in respect of which I have submitted a bank guarantee.
No, they have a clause out there in the contract.
No, my lord, that does not enable them, my lord. And in fact, I'll rely on the Apex Court judgment of 2016, my lord, where it has been stated, my lord, if your lordship would see the bank guarantee itself, it says that for the security of this contract, and whether it would be a sum due, my lord, that is a question to be adjudicated upon. Only thing, my lord, we have.
No. I am asking,
my lord,
whether as per the terms of the contract entered into between you and FCI,
my lord,
there was a term out there that if any other security,
my lord,
can be invoked.
My lord, not
because what you are submitting, that is inter alia between FCI and the bank.
But in respect of the other, my lord, because similar issues had propped up, my lord, the other case, my lord. Similarly, Section 9 petition was filed, my lord, injunction was granted. Subsequently, it was refused by the additional district judge. Then High Court also dismissed that petition. The Apex Court has said that since it's an invocation of a bank guarantee in respect of other contract and the sum due has not become crystallized, therefore, my lord, your lordship is referring to a clause. But in fact, what has happened, we have not filed our response, my lord, in this case, my lord. Only we want in this petition, they have filed an affidavit. We would have required to, my lord, file our response.
No problem. I'm not extending the stay.
Then your lordship would kindly see page para 42 of the judgment. And in between, Lord, we have taken steps to extend the bank guarantee. It's been extended till January of 2024.
You have extended?
Yes, I have. We have. I
Because
have.
till yesterday it is 37.
31/7, Lord.
That was till yesterday.
Yes. No, day before.
Day
Lord.
before yesterday.
In fact, I was.
I am
out of
not.
session in between.
I am not. I was also asking that if bank guarantee could be extended. Lord. If that is extra, I am not aware. Lord.
No. In fact, till that day it was not.
Not.
It was till 31/7.
Yes.
I remember. So we'll hear it on some other day leisurely. You file a reply because you have already extended the bank guarantee. The learned counsel for the petitioner has drawn the attention of this court that the bank guarantee bearing number, what is this number? What is number? You read it from your place. The number which you have given is
1826413.
slowly.
41G. Sorry. 18264
BG 000021.
Title 03. Dated 17/7/2018 of an amount of rupees 81,15,000 issued by the Karnataka Bank Limited. Which branch?
Guwahati branch.
Ulubari branch.
GS Road branch.
Ulubari GS Road branch have been further extended up to 31/1/2024. In that regard, the learned counsel for the petitioner have placed the said extension, which is kept on record and marked with the letter X. The learned counsel for the petitioner submits that there is already an affidavit in opposition so filed, and the petitioner would like to reply to the same and seek for an accommodation of 4 weeks. List the matter again on 28th of August 2023, on which the affidavit in reply be filed by 23rd of August 2023. The interim order passed earlier shall continue till then.
Item number 37 for orders.
Lordship, the Honorable High Court order has been complied with.
Yeah, please.
I have not received any copy, madam.
Ms. MD Bora, the learned counsel appearing on behalf of the petitioner, respondent.
My lord, sole respondent.
When it can be, my lord, time is over, madam.
What?
Madam, this is the period is over. Madam, within that period, they can comply to it. I don't know, madam. They did not serve a copy, madam. Madam, this is regarding the settlement of my lord Mohal, this question, Honorable Court passed an order on 7/9/2021. But they did not, within the period of my lord, period, they did not comply with it, madam. Whether that is complied.
Lordship.
I'm not.
May I submit, my lord?
Don't submit.
My lord.
I will hear first the petition.
Order was passed on 7/9/2021. And period was over March 22.
What is the order passed?
Order
Page
passed
15 is the
page
relevant.
15, madam.
Hmm?
Page
Page
15,
15.
my lord, the last.
Yes. Here in above stated petition of the NIC.
16, and the petitioner about the experience certificate of from the decision of the tender committee, and it's apparent that the private response number 8 failed to submit the explanation state of things in view of the chain and completion of the demand. Petition of the tender recommending the respondent in number set aside and court thereby demanding the matter to the director of the IWP to complete the tender process as per the tender conditions set with Rule 16 without there being any deviation. So that is the direction.
Yes, my lord, there is no specific direction to settle with the petitioner, my lord.
But period of settlement is over on March 22.
And after that also it
And
was
my lord,
continued, lord.
may I submit, madam?
No,
Madam,
wait,
please,
let me look
an
into
order
that.
has been passed
With
on
reference to the-
7/9/2021.
I have a content copy of the content regarding the change. Now, what is the compliance done?
After
I'm
that,
directed to inform you that on fulfillment of the provisions laid down in Rule 16 on so and so with Imran Hussain. Who is Imran Hussain?
is the petitioner.
Imran Hussain for the remaining period from 2020 with effect from taking over by the lessee up to 31/3/2022 for rupees 3,00,000 only on per year basis under the provision of 4(1) of 20. So you gave it for 5 days.
Lordship, after that also it will continue, my lord, because we have recently settled the ferry service for the year 2022-24, my lord. Recently settled, so
This is
after
a-
that also it-
another settlement, madam.
Okay.
My submission is that within the period of my lord, they did not pass any order.
What is the period?
Period, my lord, settlement, my lord, period.
Settlement period, they have passed the order.
Fine.
They passed the order on 25/3.
Yes.
Settlement period ended on 31/3. Then
There is no specific direction from this court also.
the learned counsel appearing on behalf of the sole respondent,
Hello.
respondent contemnor has submitted that in pursuant to the order dated 7/9/2021 passed in WPC number 3376/2021. The settlement process was completed on 25th of March 2022. And as such, the order dated 7/9/2021 have been duly complied with. In that regard, the learned counsel have also drawn the attention of this court, had also placed on record the order dated 25/3/2022, which is kept on record and marked with the letter X. Taking into account the above, this court is of the opinion that the order dated 7/9/2022 in 21 passed in WPC number 3376/2021 stands complied with, and accordingly the contempt proceeding stands dropped.
I'm deeply obliged, my lord.
Hey, you take this, we don't require.
My lord. Lord.
Next. In this case, service complete, my lord, respondent have entered appearance and they were supposed to file an affidavit.
There has been no compliance? What is the order passed?
Order your lordship. on the page.
Mr. Stuti has been appearing on behalf of the client. So upon hearing the learned counsel and court of the appeal, the matter can be disposed of here within the direction operated to release the balance due to the petitioner admitted to be completed within 4 months from the date of issue of the certificate. Okay. This was done on 26/10/2021. Then
Then, my lord, there was
Then
a
what?
time limit of 4 months, my
you
lord.
know, tell me, when did you serve this copy?
Lordship, we have filed an additional affidavit in this.
Ah,
Yes, your lordship will find the page 5 your lordship.
page,
Additional affidavit, page 5 your lordship. And then the postal
copy of the
receipt,
postal
page
receipt, 7/11/2022.
6 and 7.
Copy of the letter. Copy of the letter is,
Copy of the
you have given the letter on 7/11/2022,
lordship.
within 1 year,
No, your lordship.
after 1 year.
No, your lordship. It's
Yeah.
21, your lordship. The postal receipt. Access to the postal.
What is this? 7/11, request for release of the payment in respect of so and so. I have been obliged
the
if you kindly
representation,
enclose a copy of the
subsequent
which is self-explained. This is given to the additional chief engineer Kachar and Hills division.
Yes, your lord.
Only one person, but why 4 postal receipts?
Other communications were there, your lord.
What communication?
The official communications upon my representation, my lord.
Chief engineer, where is it? Commission of
Page 5,
Finance Department,
your lordship, kindly see page 5. Your
Huh?
Page 5.
page,
5, your lord.
that is what I have seen.
Lordship.
It is only to the additional chief engineer.
Yes, sir.
Then why so many postal receipts? 4 postal receipts.
Postal receipt, sir.
Then from Deputy Secretary to the Chair, inviting reference and to enclose here with a copy of the letter dated so and so is explicit. You are therefore requested to kindly examine the matter and think at the earliest as the action may be taken in so and so. Copy to so and so. Then, so he has done to the chief engineer, this is it. Done in 19. Then to the executive engineer, the additional chief engineer's request. And in this regard, you request.
Upon the same state letter, your lordship, they have made internal comment.
Huh?
Acting upon the letter dated 7/11/21 upon my letter, my lord.
Okay. It appears on record that on the last occasion, How many respondents are there? Where is the notice being issued to these two persons?
Lordship, respondent, contender number 1 and 2.
Where? Where's the notice?
It's order 22/7/22.
22?
7/22.
Where is it? Additional affidavit.
No, your lordship, notice as regard to your lordship, the contempt petition. The lordship is,
About the chief engineer, where did you issue notice to him?
so your lordship is concerned with the contempt petition.
Absolutely. When did you issue notice to him?
The notice
For
was issued
compliance.
22/7/22. Your
Where is it?
or filed order dated 22/7/22.
No, not 22/7/22. We are not concerned with that.
Lordship.
I'm only asking you, where did you issue notice to the chief engineer to comply?
If it, I have written the letter 7/11/2021.
To whom have you written?
That is your lordship, additional 15.
Then why are you drawing the chief engineer?
Because the direction your
Direction was given to whom?
Yes, your lordship, there was a direction to respondent number 4, my lord, additional
Huh?
chief engineer. Respondent number 4, additional chief engineer, page 10, your lord.
And what does Tamser Ali say?
Really, lordship,
Does it say about a particular period?
that says about the period, my lord, but
Then how do you enforce it?
uh, time frame was also given, my lord, to provide this order, your lord, within a period of 4 months from the date of receipt of the certified copy.
Chalo. They have not appeared, so we ask the person to be present, personally present. Who are these people? We'll take it up after some time. Okay? If these lawyers don't appear, no affidavit has been filed, then we'll ask these persons to be personally present. Mr. Counsel, we have a big problem. You are making the chief engineer a party. You are making the executive engineer a party. The notice you have issued is to the additional chief engineer. Tell me, how do you reconcile? How do you reconcile?
That in the direction, my lord, respondent number was directed to the respondent number 4, your lordship.
Understood. But how do you reconcile? In this case, you have made the chief engineer and the executive engineer a party. But for that, you have issued a notice only to the additional chief engineer to comply. How do you reconcile this? Okay, let us see where the other side comes. Huh? The legal counsel, the counsel for the petitioner is represented, whereas the counsel appearing on behalf of the contemners are not present. On the last occasion, the counsel appearing on behalf of the contemners have sought for 4 weeks' time to file the affidavit in opposition, which have also not been filed, as could be seen from the office note dated 4/2/2023. List the matter again on 28th of July 2023. In the meantime, if the respondent contemners do not file the affidavit in opposition or are not represented, this court shall pass appropriate orders seeking their personal.
File
39.
Yes.
My lord, speaking order has been passed, order has been complied, my lord.
Complied.
Complied. Also, my lord, see the order sheet. There was also delay on the part of the petitioners of approaching this court, my lord.
Mr. Counsel, are we not have, don't have, we have the power under 215?
Lordship has power. But my lord, there was delay, but it was not deliberate because new rules had come into force and COVID had set in, my lord.
So you have rejected his petition.
My lord. Because totally new rules, new set of rules had come in, my lord. He agitated his case in a different set of rules, my lord.
Where is the direction passed by this court?
Direction, my lord,
Page 10, Lord, if relevant part is page 12.
it was 30 days, man.
Considering the submission of the opinion, reason can be disposed of the motion, sir, which thereby allowing the petitioner to submit a representation before the response, highlighting the required formalities to be followed, including the necessary environment clearance and so on. The same shall be disposed of by a speaking order within the outer limit of 30 days from the date of submission of the representation, keeping in view the rules holding the field. The instant contempt proceedings have been initiated on the basis on account of non-compliance to the order dated 7/1/2020, passed in WPC number 94/2020, whereby the petitioners were given the liberty to submit their representation before the respondent number 1 and 2 in the petition, highlighting the required formalities to be followed by the petitioners, including the necessary environment clearance from the competent authority, and with further assurance to pay the required payment oblique taxes as per rules within a period of 15 days from the date of the said order, whereafter the same shall be disposed of by a speaking order within an outer limit of 30 days from the date of submission of the representation, keeping in view the rules holding the field. It further appears that pursuant to the said order, a representation was submitted on 11/1/2020 by the petitioner. However, as there was non-compliance to the no orders were passed, the instant contempt proceedings was filed. Mr. D. Gogoi, appearing on behalf of the respondent
Number 2, my lord.
number 2, had submitted that on 17th of June 2022, the order has already been complied with, thereby the representation of the petitioner was rejected. In that regard, he has placed on record the representation which is kept on, he had submitted the order dated 70. In that regard, he has submitted the order dated 17/6/2022, which is kept on record and marked with the letter X. Mr. Name? So and so, the learned counsel appearing on behalf of the petitioner, however, submits that the order dated 17/6/2022 is not in consonance with the order passed by this court on 7/1/2020. This court, having given an anxious opinion, anxious consideration to the matter, is of the opinion that the order dated 17, that the order dated 17/6/2022 is an order, is a speaking order in terms with the order dated 7/10/2020. Passed 7/1/2020, passed in WPC number 94/2020. However, if the petitioner and as such, the instant contempt proceeding stands closed. It is, however, observed that if the petitioner is aggrieved with the order dated 17th of June 2022, the petitioner would the petitioner would be at liberty to assail the same in accordance with law.
The order may be found.
Give it to him. One copy.
I am giving him right away.
40. Yes.
This is the
Yes.
contempt, my lord, for
What is
non-compliance.
this affidavit? Why not
Affidavit not
filed?
yet filed, Lordship. The compliance status has not yet been given to me, but what has been informed to me, Lordship, may kindly see at page 9, Lordship.
Yes.
is that this is the work order issued to the contractor, Lordship, and
Yeah.
what has been informed to me, Lordship. This entire scheme of 2016-17 is a fake one, Lordship. Under this scheme, 420 crore has been spent. I mean, no money was there, but work order has been distributed. Works has been done, Lordship. Now the bills are pending, and the matter is presently under investigation of CM Vigilance, Lordship.
Then why you are not passing an order to the
Lordship, because of that investigation.
after hearing the learned counsel for and considering the aforesaid order of the principal secretary so and so, it is directed that the respondents in the BTC, after completing the necessary formalities within the stipulated period in terms with the said order, shall consider to pay the admitted amount to the petitioner as per his entitlement at an early date.
Lordship, that was one audit was going on, Lordship. An agency was appointed. That audit agency has given its report in the month of March 2023. But those were in respect of SOPD projects, Lordship. But this is under a central government scheme, Lord.
You are to pass an order.
Lordship, that is why, Lordship, I am intending to file one affidavit, Lordship. I need to bring this in record,
Monday?
Lordship. This is not the only case, Lordship.
Monday,
There are so many cases, Lordship.
Monday?
We are preparing one list, Lordship.
Monday.
Monday, it will be too early, Lordship.
Then
In-
then ask the contender to be present.
Lordship, now at present, Lordship, he is no more the principal secretary of BTC, Lordship.
So who is there?
Now one Akashdeep has joined now.
We'll ask him to be present.
Lordship will give me some
Monday.
reasonable time. In the meantime, Lordship, I'll find
You
one
want
affidavit.
to bring, because why haven't you brought that attention at that point of time and when the court had dealt with the matter?
Like it is subsequent revelation, Lordship.
Then the
Subsequently, it
subsequent
came to the-
revelation, this is a matter of 2016. The work order is of
16,
2016 and this order has been passed as far back as on 2022,
Lordship,
Then-
this inquiry was ordered in after 2020, Lordship.
which is the order you are challenging. The contempt is
My
which order?
But page number 22, madam. 24, madam.
During the execution of the work.
And these
Which one? 10 to 2022?
Page 24, Lordship.
Learned counsel for the parties submitted at the bar that the issue involved in the reply is covered by the decision of this court on so and so, passed in so and so. In view of this, the repetition is disposed of in terms. Huh?
And similar order is page number 26. Lordship, in that order, no specific time was there, Lordship. A direction was issued to after audit, Lordship, to pay them in terms of temporary, Lordship.
All exercise would be done within the month.
No, where is Tamsir Ali? Tamsir, you have not read the order. There is no
Lordship,
Tamsir Ali.
kindly see page 26, Lordship. It starts from page 26. That order is at
No,
page
un-
26.
Understood, but here there is an order of 15th of November
In terms
2021.
that or this present case was disposed of in terms of this order, Lordship, 22, 12,
With regard to the
2020.
payment admitted amount of the contractors and so and so. No, at that time, with this document of 15th of November 2021, which is quoted
the
at
same.
page 29.
First continuation.
If all matters were disposed of, many of the matters I have also disposed of,
Lordship.
then you are to take a decision on in accordance with this. Why haven't you taken a decision?
Lordship, under this notification, Lordship, only those projects under SOPD, those were audited, Lordship. But this is under a particular separate central government.
So you are saying that this notification of 15th of November 2021 is not in relevance, is not in connection with this work.
Now it appears, Lordship. Now it appears, Lordship.
Then why haven't you
Initially,
filed your
all the-
affidavit?
Lordship, that
Here
is
the
why-
notice was issued on 21/11/2022. Are you waiting for this person concerned to get transferred and then to file and say that this person is not there?
Lordship, in
And
fact-
thereby to make it
No,
infructuous?
no, Lordship, in fact, we are-
Mr. Nayak, we are asking that Anurag Goyal or whoever he is, let him be personally present on Monday.
Lordship will grant me some time to file one affidavit, Lordship. Because
Monday.
This is not
Monday.
the only case, Lordship.
Monday.
Lordship, after considering the affidavit, Lordship may.
No,
direct for
Monday.
Personal appearance, Lordship.
No, that is why I'm saying, either file your affidavit by Monday. This is not done. Why have you allowed? It is because of this has happened. The notice was issued as far back as on 21/11/2022. We are in 2023.
Lordship, because, but the notice was issued.
This
even
is
prior-
how you make
No.
the contempt proceedings infructuous.
Lordship.
That and thereby asking these petitioners from
Lordship,
running from
just
this way
one-
to
just
that way.
One submission, that notice was issued, Lordship. When the
Mr.
contempt-
Nayak, this court is not inclined to do all these things out there. I'm not a person out here who is going to allow these contempt proceedings to be taken for a ride. at the instance of the officials out there in
Lord,
this.
I'm just praying 7 days time to file the affidavit.
Okay, then file it by Wednesday.
Lord.
26, we have it on 26, you file your affidavit.
Today is the ninth.
Mr. Huh? 42?
That's a different case. No, I'm not dealing.
Okay. Mr. P. Naik, the learned counsel appearing on behalf of the contemnant, submits that he would like to file an affidavit, taking into account that the notice was issued as far back as on 21/11/2022. So this court grants an accommodation for filing of the affidavit by 26th of July 2023
Lord,
without fail.
Lord, may I-
List the matter again on 28th of July 2023. It is made clear that even though affidavit is not filed by 26th of July 2023, the person, the contemnant shall be personally present in the court.
Lordship, here the petitioner worked under the SOPD scheme. Audit has been done. Lordship, only I have to take the instruction on the status of his work. Lordship may give me 1 week time. Because they have preparing the list to make payment under the terms. Only the status report with regard to his work, Lordship.
Mr. Chaudhary, you file your affidavit by 26th. Whatever may be.
Yes, Lord.
You see, in the contempt proceedings, the thing is like this. Either you have to comply with or file an affidavit why it has not been complied. If it is not complied with, we some circumstances are there for which we may extend the period out there, whatever may be. Maybe there might be, because here is a case of there is a direction for verification. Now, once the verification, you may find out that they know non-verification he is not entitled to.
Yes.
So something has to be brought on record by way of an affidavit. This is a contempt proceedings after all.
Yes.
So you have to bring it by way of an affidavit that he is entitled or he is not entitled to. If he is not entitled to, we'll take note of that. And if he is entitled to, we'll pass appropriate orders to them. Mr. B. Chaudhary, the learned counsel, appearing on behalf of the petitioner, on behalf of the respondent,
One
on behalf
and
of the co-respondent, or one,
and two.
appearing on behalf of the respondent number 1 and 2, submits that he is going to file the affidavit by 26th of July 2023. To list the matter again on 28th of July 2023. It is made clear as the notice was issued on 23/11/2022. If the affidavit is not filed by the date so fixed, the contemnor shall be personally present in the court. 43. Huh?
Order has been complied with, my lord. Correct.
The instant contempt proceedings have been initiated on account of non-compliance to the order dated 26/10/2022 passed in WPC number 6597/2022. Miss
M. Borman, ma'am.
M. Borman, appearing on behalf of the
1 and 2.
respondent numbers 1 and 2, submits that the order has been duly complied with, and in that regard had placed on record a communication dated 3/2/2023. The said communication is kept on record and marked with the letter X. Taking into account that the order has been duly complied with, the instant of contempt proceeding stands closed.
44.
May I please, Lord.
Hmm.
But we already complied, my lord, and main writ petition was also withdrawn, my lord. So this is a contempt was filed against the interim order, my lord.
Hmm.
Lordship may kindly take the affidavit filed the respondent number 1, my lord.
Yes. What is the order passed
Lordship.
against the order dated
Stay order
9/12?
was done, my lord.
What was the direction be there in the judgment
My
dated
lord, my
whereby
lord.
the provision of the remand has been held to be in line with court is inclined to stay the operation of the impugned order dated issued by remand insofar as the market, if any, standing in the land of
order was stayed, my lord.
Ah.
And thereafter, my lord, page number 31 was passed by the deputy commissioner, my lord. And my lord, thereafter, they have withdrawn the writ petition. my lord.
Mr. S. Dr. the learned counsel appearing on behalf
I'm
of
for 2 and 3, my lord. And my
respondent
colleagues.
number 2 and 3. The instant contempt proceedings have been initiated for non-compliance of the order dated 9/12/2022 passed in WPC number 6702/2022. The learned counsel, Mr. S. Dr. the learned counsel appearing on behalf of the respondent number 2 and 3 has submitted that pursuant to the order dated 9/12/2022, the District Magistrate Nalbari by an order dated 8/2/2023 have duly complied with by keeping in abeyance the operation of the order dated 26/9/2022. He has further submitted that in the meantime, the writ petition, that is WPC number 6702/2022 has also been withdrawn by the petitioner. So taking into account the above, the instant contempt proceedings, taking into account the above, and more particularly the order dated 8/2/2023 issued by the District Magistrate Nalbari, the instant contempt proceedings stands closed.
Highly obliged, my lord.
45,
Appearing for respondent number 6, my lord, and file my affidavit, my lord.
You have filed your affidavit.
Yes, my lord. The remaining, not,
But why the matter has come?
my lord, as per Lavazima court order dated. Lord,
Your respondent number 6,
Yes.
Tezpur.
my lord, no, my lord, private respondent.
Who is appearing for respondent number Tezpur Municipal Board?
No one is appearing, my lord, just before vacation, my lord, they have served the notice, my lord. There is a Lavazima court order dated 13/6/23, my lord.
You normally appear for Tezpur Municipal Board, na?
Not always, my lord, whenever they, my lord.
2 days back you appeared.
My lord.
You appeared, no. There's somebody else.
My lord, 2 days back.
You appeared,
Yeah,
na?
my-
Okay.
Only for the chief executive
Huh?
in that case.
You were there, and on the other hand, there's another. The office notes, the order of the Lodgement Court dated
13/6/23.
13/6/2023 reveals that a service upon the respondents are duly complete. Accordingly, lists the matter for admission on 7th of August 2020.
Much obliged. Okay.
46,
The petitioner, so petitioner, you want to file an affidavit?
Yeah, I have filed a reply, my lord.
You have filed a reply.
We are going to file a reply.
The petitioner in the meantime is to advise to be at liberty to file the affidavit in reply.
46,
Same type. In the matter that this no matter.
I think in the morning, my lord, item number 2 and 53 and 54 from orders of past. But
Two
these
and,
two were, these two matters were left, 46 and 48.
Same matters, na?
Same one. NHPC.
No, no, there the petitioner had appeared.
In one case,
No, in those two matters, the
Uh-huh.
petitioner had appeared. Item number 2 and item number 50 something.
53 and 54.
One
There are
matter,
two
not
matters. Huh? Only in 54. Yes, 2 and 54, my lord.
he had only appeared in 2. Here they have not appeared. Hidden at the people as to whether the principal seat to transfer on to compensation. It was at the order like to pass to list after 4 weeks.
Items will be, my lord, 46, 48 and 53. 48,
And 53.
Same order, huh? Hit na order to next.
54 to appear course.
Because there the petitioner has appeared.
Yes, my lord. No,
Mr. PD Nair is appearing.
yes, ma'am.
Here the none is appearing. So
No,
I
none is
think this information has to be given to respondent
lord,
number 2 and
today
3
is to my
as
lord.
well as to the petition.
Today is finished.
You know, he's named non-appeal. Huh? It might be after 4 weeks.
My-
47,
Order has been complied with, my. Order at the 23.
The instant contempt proceedings have been initiated for non-compliance with the order dated 23/6/2022 passed in WPC number 3989/2018. Mrs. N. Saikia, the learned counsel appearing on behalf of the petitioner, submits that the order has been duly complied with. Accordingly, the contempt proceedings stands blocked. You give your name, huh, in the slip.
49,
Lordship order has been complied with. I'm for respondent number 1, Lordship.
Respondent number 2.
Violation of which order?
So there are 3 or 4 orders. There are in totality 3 or 4 orders, one in IA, one in review, 2 in writ
There's
petitions.
13 laws.
All have been complied with, Lordship, and the order has been served upon them.
The instant contempt proceedings have been initiated on account of violation or on account of non-compliance with the order dated 5/1/2017 in WPC number 6789/2015, read with order dated 29/2022 in IA civil number 1273/2022. The learned counsel, Mr. S.
Saraf. D. Saraf.
D. Saraf, appearing on behalf of the respondent number
1.
Respondent number 1 had submitted that the orders have been duly complied with. The learned counsel for the petitioner also submits that the order has been duly complied with. Accordingly, the instant contempt
Reference of order may
proceedings.
be given law.
Huh?
Reference of order, my lord.
Order dated 12/5/2023. He is asking for a reference of the order in the order.
You want the reference in the
Because my lord, another posting is when my lord pending one. Review
It
petition
is
is pending,
12/5
another. contract is pending.
12/5/23,
That is why,
Lord.
lord.
You have the copy of the order.
I will have to, today I will not be able to provide, Lordship.
My lord, I have a copy, lordship.
You have a copy?
Yes, lordship. That
Have
is
been
why, my
duly
lord.
complied with on. To me?
Lordship, the respondent number 1 got transferred.
Been duly complied with.
This is the order, lordship, please. My lord, with me. My lord, because, other pending, matter pending, that is why. Yes,
Have been duly complied with on the basis of an order dated 12/5/2023 passed by the Circle Officer, Guwahati Revenue Circle. Itu agokni the has been duly complied with. Okay. You have a copy, extra copy? No. You make a photocopy and give it.
Yes.
Photocopy to koi. The said order is kept on record and marked with the letter X. Huh? In view of the above, the contempt proceeding stands closed.
Obliged, Lordship.
You just it X mark to it.
fifty,
Wait, please, your lordship.
Yes,
This
Mr. Manan.
matter, trustee service was directed to be given to the respondents.
Hmm.
We have filed the affidavit with regard to compliance of the service of trustee. Your lord. The
Hmm.
affidavit was on the last occasion, not before the court.
Affidavit regarding Dusty is there on 15/3/2023.
Then, your lordship, it has been
Huh?
served.
affidavit regarding Dusty
On the last occasion, it was.
on
not
behalf
there.
of the respondent number 3, this affidavit is filed. Where is the Dusty affidavit?
Dusty, your lordship will find at page 32 of the affidavit. 32, 32, all the three. Then 36 and
Of the
40.
The service is complete upon
Service
all,
is complete.
taking into account the
Matter may be listed
affidavit.
by admission.
affidavit of service as well as the order of the Lozima Court dated 3/5/2023. The service upon the respondents are complete. Accordingly, list the matter for admission on 9th of August 2020.
Much.
51,
May I please, your lordship? As per Lozima court order, lordship, notice upon the respondent number 4 to 11 and 13 is deemed to be served, lordship.
No, your lordship, I am appearing on behalf of respondent number 13. May I be allowed to file my affidavit? I filed my workout number today itself.
Your name?
P. Sharma. P. Sharma.
P. Sharma.
Yes.
The learned counsel appearing on behalf of the Mr. P. Sharma, the learned counsel appearing on behalf of the respondent number 13/6 for an accommodation of 4 weeks for filing his reply affidavit in opposition. List the matter. It further appears from the office note dated 8/6/2023. 8/6/2023, as well as the order of the Lozima Court dated 9/6/2023. That a service upon the remaining respondents have been deemed to have been served. Taking into account the above, list the matter for admission after 4 weeks.
Lordship, interim order passed earlier.
Oh, then we have it on, we fixed on 23rd of August. Interim order passed earlier shall continue.
52. May it please your lordship.
Yes,
Lordship, this matter relates to a rejection of the applications of the petitioner for minority scholarship. And in fact, pursuant to the last order, your lordship,
Mm.
the institute has already forwarded the verified documents to the respondent, your lordship, and the district nodal officer in his turn has forwarded the same to the director of Territorial Development for doing the needful, which is reflected in the affidavit filed by the
now whether the service is complete or not,
service.
madam, you are appearing for?
W2 and 3, my lord, but as per
Mr. Khan, you
the
are appearing for 6. Who else is there?
7, lordship, the private respondent. As per the office note dated, lordship, 22/6,
And
my
the
lord.
AD card, no,
Yes,
answer
my lord.
notice on behalf has been received.
Dusty service was permitted, we have served to the state.
To respond number 7?
7 also. Affidavit in that regard is filed, your lordship, at page number 42 of the
Where? Page 40?
42, 42 it starts from, and that page 47 is the
I think from page 41, my lord.
Respond number 7, Subroto, you are 6.
6 plus.
Subroto Nath.
My lord.
And 7 is Sifa Pharmacy Institute.
but the petitioners are undergoing the process.
They did not provide the documents to the school inspector, so that their verification could not be done by the inspector of school, my lord.
Okay.
Yes, ma'am. For the scholarship, my lord.
Have not submitted.
No,
have
the
submitted
institute,
your
the
lordship.
institute did not submit it, the Sophia Institute. 7.
That's pursuant to the order of this court, your lordship. Last order, if your lordship goes to the order
I've seen it.
2/5/2020.
Okay, the service is otherwise complete.
Something.
My lord.
Okay.
I have also received instruction, my lord.
You want to
Okay.
file an affidavit?
My lord.
Okay.
Maybe
Ms.
dispose
M. D.
of
Bora, the
the-
learning counsel appearing on behalf of the respondent number
2 and 3, my lord.
2 and 3 submits that she has received the instruction and would be filing the affidavit within a period of 3 weeks from today. Mr. Khan, you are filing your affidavit.
Already filed.
Okay.
The matter
You are
is-
filing a reply?
to us. if it takes long time because it is a scholarship for this year only.
We fix a date. Na? You want to file a reply to that? Respond number 6.
In fact, my lord, may kindly have a look my instruction on the second paragraph. Dispose of the matter.
Not today. It's already.
No, I will bring it on record, my lord.
You'll bring it on
My
record.
lord.
It's come up for orders.
My lord.
It further appears from the record that the respondent number 6 has also filed an affidavit in opposition. The petitioner is to advise is at liberty to file their reply. List the matter again on taking into account the matter, the urgency shown by the learned counsel for the petitioner. Let the matter be listed again on 16th of August.
My lord.
The affidavit be filed without fail filed by the respondent number 2 and 3 by 10th of August.
Lordship may kindly record respondent 3. I have received instruction from 3. He is the
But you are
authority.
paying for 2 and 3.
Both, but only one affidavit is sufficient.
Oh, 2 and 3.
If you kindly fix the date on
You
17 or
File on
16.
behalf of respondent number 2 and 3. File on behalf of the state. Your state, na?
Lordship,
2
I'm
and 3
Standing Council WMD department.
appearing on behalf of the affidavit of the official respondents be filed by respondent
Right.
by 10th of August. Yes.
My lord.
Lordship, if the
I'm
lordship
listening.
permits the lordship to fix the date either on 17 or 14, 16 I may not be able.
17th is not possible. 18th is closed. 14th is August. 14th is okay. We have it on 21st. 21st, and then let her file the affidavit by 16th of August.
Lordship, I will find lord. Deeply obliged.
Apply that.
56.
He not will appear, my lord, can I allow to call.
Yes, Mr. What is your case?
Hello, this case is in regards to one complaint filed by me and Hemanta Devri before Director Vigilance and Anti-Corruption on 27/11/2018 against one Dr. Durlabh Samoa, who was an ex-MLA, for disproportionate assets from non-source of income. Accordingly, Government of Assam ordered an inquiry in January 2019, and Director Vigilance and Anti-Corruption started the inquiry accordingly of his assets and income comparisons. About after 2 years, on 13th January 2021, they filed a report to the government stating that they found rupees 2,16,05,000 something amount of disproportionate assets. And they need government approval for initiating criminal case registration, prosecution sanction.
Who say?
Director Vigilance and Anti-Corruption has sought from the political department. The competent authority is the Chief Minister Assam. The instant cases in the about 2 years from 2021 to 2023, we are following up with the representation, RTI applications. We are getting the replies also, but there is no decision taken. The required RTI reply.
What is your name?
Vikas Bucha. I am joint complainant along with Hemanta Devri.
How are you connected with this thing? Why you are filing this against that?
I am the original complainant, my lord. Annexure 1, page number 23.
Understood. But why have you filed a complaint? How are you connected with this person, the MLA?
Actually, yeah, it is known to me for very 10, 12 years. And after 2016, when this social welfare scam was exposed, and we have sent some small, these officers are just being targeted, but the big fishes are scot-free. Only some officers has been arrested, and media hype has been made that government is doing so much to curb the corruption. This social welfare scam is over 2,000 crore. About
This is
9
social
lakh
welfare.
fake children are there.
Social welfare.
Yes, my lord. This person was the main agent of the then minister who managed the entire scandal. We have just given some few properties details. My lord, few of the properties are directly purchased in the name of his wife, his minor daughters, who either just completed the age of 18 when he was MLA between the 2011 to 2016. 3 properties were attached by income tax department directly in the name of wife and his daughters are the flats in Guwahati. 9 lands in Nagaon against the income tax attachment order under the BP. They filed writ petitions in 2020 before this court on stay on the ground of retrospective.
No, Mr. Counsel, have they till now registered a case against him?
No, the government has denied the prosecution. Last date, please go through this last order where the government denied that they are not going to give the prosecution sanction.
Why?
The Mr. Justice Sulana order returned the instructions and asked them to file it.
Instruction from the political leader to inform that with the approval of the government, the director have denied to grant approval of the respondent number 5. Let the matter then be brought on record by way of an affidavit within a week. And they have not filed affidavit.
They have not filed affidavit.
We call this director. What is this? Director of Vigilance and Anti-Corruption. Who is he? We'll have it on. Where is he?
It might be in some lake, I didn't pick up my phone. So
This is the last item.
another 2, another one.
Why has he not filed the affidavit? Prosecution is sanction. Sanction is required for what?
Registration of criminal case.
Criminal, no. For registration of a criminal case, sanction is required, or for filing a for the purpose of filing the charge sheet. Mr. Mohanto, kindly help us. Why do you require a prosecution sanction? Is it for the purpose of filing a charge sheet?
No.
For what?
Only cognizance.
Only for the purpose of cognizance. Now, have they registered a case?
No, my lord. Because we don't get the government's reply yet. Once we reply, we will request you to give an order so that we will approach the magistrate. Once we go to magistrate, he will say, not this is, they go to vigilance and anti-corruption. So until and unless they will just give it in writing to me that they are not going to do anything. So that we will seek your permission and accordingly go to the trial court. Because it is the trial court will decide whether the properties are disproportionate or not the chief minister. My lord, I would like to brought one order passed by you on 21/12/2021.
Where?
In the same properties which I have mentioned at item number 1, 2, 3 in my annexal 1, page number 20.
My order.
Yes, yes, my lord.
Where?
This is in regards to the BP. The petitioner are the wife and daughters of the respondent number 5. They have filed 3 numbers of the petition, obtained the stay order on the income tax provisional attachment order. And this is the order, my lord. And there is a very massive proof-ups. Since your order for a detailed hearing, 19 months, this case has not listed.
This is some challenge to something, no?
Yes, my lord, same property, which I have mentioned in my application. to vigilance and anti-corruption, same property.
This is by the income tax.
Yeah, this is by income tax. Income tax department also found that we have filed money complaint information, and accordingly.
Mr. Mohanta, you are appearing in this matter?
No, I'm not.
Because of this, no? Okay. Okay, we'll take it after some time when he comes. Else we ask the director of finance to be personally present. Why yes?
57.
Yes, what is this matter?
Notice was issued on 24/23. Service upon the private respondents are completed. Only 18 is awaited.
This is a performer. What is the matter about?
Matter is proposed against the setting up of biomedical waste treatment plant.
Consent to establish. Okay. Yes. You are appearing for?
1 and 3, Lord.
Who are they?
The company, the Caspa Environment Management Private Limited and the director.
Huh?
They are against the consent to establish of a biomedical waste company. We are for the company and the director, Lord. 1 and 3.
So you have got the year to establish.
Yes.
And this is a case of pollution.
Yes, one.
Who is appearing for the pollution control?
Siddhartha Gurkha is appearing. He is not present today. I'm appearing.
Why haven't you filed your affidavit? Is there a stay order?
No.
No, Your Lord.
So
They have
for
already
the
filed that
first
one.
time today, it is listed after service of notice. Therefore, we'll file an affidavit. But otherwise, as per the Lojima court's order, dated 18/7, all have been served except 18 who has been deemed to be served. Therefore, service is complete. Lottie may pick it for admission. In the meantime, we'll file the affidavit.
You file or not, that is your lookout. When are you filing it?
For 2 weeks.
You?
After within 2 weeks. Within 2 weeks.
Mr. B.P. Bora, the Learned Counsel, appearing on behalf of the respondent number 1, 2, and 3, submits that the affidavit to be filed by the state respondents within 3 weeks from today. Miss
D. Datta appearing on behalf of S. Gurkha.
E. Datta.
D. Datta.
E. Datta, Learned Counsel, appearing on behalf of the Pollution Control Board, submit that the affidavit would be filed within 3 weeks from today. List the matter again on 21st of August 2023 for admission. It is also this court further finds it relevant to observe that the service that from the perusal of the Lojima court's order, the service upon the respondents are complete.
Deeply.
56.
So, we'll take up after some time. Let him come.
Okay.
Yes, Patu. $101. $99. Yes.
At number 99, part 2 hearing list, civil bench 4.
This is regarding my lord stone crusher machine that we need to establish in a residential area. And these three petitioner, they are directly agreed because one is my lord, it is always my lord, it cannot be within the 300 meter, my lord. But we are living in that, my lord, within 300 meter, and petitioner number 3 is my lord, he is within my lord 30 feet, my lord. So then, my lord, some report has been called for. Government file some report to the report is also probably going to hand of the government. And my lord, another thing is that, my lord, just 2 days ago I came to know that respondent number 10. Respondent number 10
he's the owner of that stone crusher unit. So he is no more. So since he is no more, my lord, they are already represented. If they give the name, my lord, then I can substitute, my lord. Because who is the now, my lord, running that stone crusher machine? But even otherwise, my lord, all I have also filed reply.
Ms. P. Hazarika, the learned counsel appearing for the respondent number 10 that the affidavit on behalf of the respondents have been filed. However, it has not been brought on record. He has been registered to put the affidavit on record. So you are against the stone crusher unit.
My lord,
And what is this pollution control board doing?
the main part, yes, pollution cushion part is the main, my lord. Because they are giving the certificate of operation, my lord. Consent of operation, my lord.
And have they filed an affidavit?
Pollution control board. No, yes, that's the pollution control board. Pollution control board. Phone number. Phone number 6. 67. From the affidavit of the respondent number 3, my lord, that is the filed by the deputy commissioner, my lord. Phone number 3. Phone number 2. Phone number 3. Phone.
Your case is come under the Air Prevention of Control Pollution Act.
Yes.
What about the Green Tribunal?
No, my lord, it is my Assam Stone Caster Establishment Regulation Rule 2010.
Understood, but are you not complaining about pollution? Wouldn't that be more effective nowadays? Your case, you can be the torchbearer for everybody.
That's true, my lord. But
No. In fact, yesterday, where I was, I'm saying, yesterday I was there. 5 years have been completed. Recently, every 5 years, report of the Green Tribunal is being sent to us. And it is being mentioned out. The power which is being exercised by them is enormous, more effective, and the penalty which is imposed, too good. And there's the appeal is only to the Supreme Court.
that is that's correct, my lord. But there is a judgment, my lord. These are case pending since 2014.
Understood, but the Green Tribunal came in 2010. Anyway,
My lord, I'll very second. I'll see, my lord, because these 3 persons, my lord, they are already, my lord, they became whole also. They cannot come to the court also now. These 3
because
persons,
this is Assam Stone Crusher Unit regulation is again under the Air Pollution Act.
my lord, they are correct. 1981. Yes, air pollution, under air pollution.
A stone crusher shall be established at least 300 meters away from the
From the-
residential area, having a minimum population of 100 to 150 people or 20 houses, including both kachra and thatch. 500 from residential having a population of more than 150 or 200. Now, in your locality, how much is the population?
Population, my lord.
Who is appearing for the pollution control board? For the respondent number 10, who is the
Respond number 10.
Phone number that. Yes, Burua, my lord.
And he is not interested.
My lord, today, my lord, I think he is not available, lord. My lord, some personal problem, he could not come, lord.
Or no, so yeah. Chalo. Mr. Mohanto, we'll take it up tomorrow. We'll take it up tomorrow.
My lord, there is a order, my lord, on 15/6/2018. By this order, court, my lord, this honorable court, my lord, in 3 point, they were asked to file affidavit.
Whether they file or not, we don't know. Yeah. Hey, on Kali, item to on Bahir list on my this is 199. Will be taken up immediately after completion of the part 1.
My lord.
This will happen by around 2 o'clock.
My lord.
Because my luggage notice এখন দি দিব কিন্তু এখন লিস্ট এটা কৈ দিব যে part 2 লম after 100 after 99 and 101 on so it is file on we'll take it up tomorrow because here we'll have to pass direction. If they don't appear, then we have no other option. Then we'll pass the direction of closure. The instant petition has been filed seeking a direction for further investigation of Hailagandi PS case number 255/2012 bracket GR case number 784/2012, registered under section 147, 149(8), 149, 447/325, /326, /336, /427, /302 IPC by the Central Bureau of Investigation or by the State Criminal Investigation Department, so as to book for trial all the culprits named in the Azahar dated FIR dated 18/7/2012. It reveals from the records that the respondent number 4 has already filed an affidavit in opposition. In the said affidavit in opposition, it has been mentioned that pursuant to the investigation being carried out, the charge sheet number 294/2013 dated 24/12/2013 was filed under section 120B bracket 147/148/149/427/447/323/324/326/302 302 of the Indian Penal Code in connection with Hailakandi PS case number 225/2012. Taking into account the above, as the charge sheet has been duly submitted and the criminal court have been already put into motion, this court does not find any grounds for passing issuings of any writ as have been sought for. Consequently, the petition therefore stands dismissed without prejudice to the petitioner in the criminal proceedings so initiated against the accused, without prejudice to the petitioner before the criminal in the criminal proceeding. The LCR so received is returned. Stay with me. No, stay with me. LCR to the call for return go second photocopy ni. This is a photocopy. Without prejudice to the petitioner in the criminal proceeding, being sessions case number 45/2014 pending before the court of the session judge Hailakandi.
Hundred and two.
Mr. Borpuzari, kindly come to this matter. They give him the extra copy. Oh, who is there? Oh, you there? Here the circle officer says
My lord.
that the land is a roadside land reserved by dark number 268 Tihu Town under Tihu Moza and does not belong to the Tihu Town Committee.
Yes.
Now here it says has raised Tihu Town Committee raised objection in respect to illegal permanent construction of shop on the roadside reserved land number 262 of Tihu Moza. Objection raised by the year dated so and so. Then that is the objection filed. Then affidavit filed by Tihu Town Committee. The foresaid occupiers are not property construction of Tihu Town Committee. Not the property construction of the. So Tihu, their basis is the Tihu Town Committee is trying to evict them. And they have got a stay. And all along they are enjoying.
My lord. Per se, town committee cannot be the owner. Either government has to be a owner or my lord, the settlement holder. Tihu town committee, it is only my lord. And my lord, entity formed under the municipal cap. If some land is
The instant writ petition has been filed. Seeking being aggrieved by the impugned notices dated 27/11/2014 bracket annexure 4 series issued by the respondent number 4, whereby the petitioners have been directed to vacate the possession of the rooms oblique shops under the Tihu Town Committee. The case of the petitioners herein is that the petitioners are doing their respective business in the shops allotted by the Tihu Town Committee, which are situated at Feeder Pot in Tihu Town. In support of the above, the petitioners have enclosed various rent receipts issued by the Tihu Town Committee, which have been enclosed as Annexure 1 series. It is the case of the petitioner that the Circle Officer Tihu Revenue Circle have issued a communication to each of the petitioners, have issued separate notices to each of the communications, to each of the petitioners, all dated 27/11/2014, thereby directing the said petitioners to vacate the possession within 7 days from the receipt of the said notice. This court have perused the Annexure 4 series, wherein it appears that the Circle Officer Tihu Revenue Circle have specifically mentioned the land to be a government land for road covered by dark number 268 of Tihu Town under Tihu Moza. It appears from the records that this court, by an order dated 11/12/2014, had issued notice making it returnable by 29/1/2015, and till the returnable date, the operation of the impugned order dated impugned notices dated 27/11/2014 was suspended. It further reveals from the record that the interim order has been extended from time to time. and at present is subsisting. The record further reveals that the respondent number 4, that is the Circle Officer Tihu Revenue Circle, had filed an additional affidavit on 8th of March 2018. Why did you file an additional affidavit without filing an affidavit?
It appears to be typological error, my lord.
I filed an additional affidavit on 8th of March 2018. In paragraph number 6, it was specifically mentioned in paragraph number 6 of the additional affidavit, it was specifically mentioned that the land in question is a roadside reserved land bearing DAG number 268 Tihu Town under Tihu Moza and does not belong to the Tihu Town Committee. It was further mentioned that the Tihu Town Committee had also raised objection in respect to the illegal permanent construction of shops on the roadside reserved land bearing DAG number 268 of Tihu Moza on 24/9/2014. The record further reveals that the respondent number 3, that is the Tihu Town Committee, had also submitted an affidavit on 18th of April 2018, wherein it has also been mentioned that the shops, rooms on which the petitioners are doing their respective business are not the property of the construction of the Tihu Town Committee. It was further mentioned that the petitioners are unauthorizedly occupying their aforesaid shop oblique room with illegal construction. Full stop. The record further reveals that an affidavit in reply was filed by the writ petitioner. Wherein it has been mentioned that the writ petitioners are occupying the shop situated within the municipal area of Tihu Town Committee, and the writ petitioners have been paying the rent to the Tihu Town Committee for such occupation. Therefore, the occupation of the writ petitioner in the Tihu Town Committee cannot be said to be illegal. Next. Mr. Arbor Pujari, learned counsel appearing on behalf of the Revenue Department, has submitted that the land in question is a government land, is a roadside reserved land of the government. And as such, the respondent circle officer,
Yes, my lord.
respondent number 4, who is the circle officer Tihu Revenue Circle, was within his jurisdiction under Rule 18 of the settlement rules to issue notice for which the question of interference by this court does not arise. I've also perused the materials on record, and there is no document on record to show that the land, no, I've also perused the materials on record. No. Upon perusal of the materials on record and hearing the learned counsel appearing on behalf of the Revenue Department, as well as on behalf, this court is of the opinion that if the land is a government land, that if the land is a government land and more particularly a roadside reserve land, the petitioners have no right to remain in occupation of the said land. In view of Rule 16,
Yes, Rule 16.
Rule 16 of the settlement rules. Full stop. This court further takes note of the affidavit filed by the respondent number 3, who categorically deny that the structures on which the petitioners are carrying on the business belong to the Tihu Town Committee. Under such circumstances, this court is of the opinion that the petitioners therefore had no right to occupy the government land. The impugned notices all dated 27/11/2004,
14, my lord.
14,
14.
enclosed as Annexure 4 series to the writ petition, therefore do not call for any interference. Accordingly, the instant petition stands dismissed. The interim order passed earlier stands vacated.
Okay.
Part 2 matter, no dismiss for default. It finishes up. Because you never get this chance any further again.
My lord, my lord. Otherwise, my lord.
No, they will again, because they are obtaining the stay,
Yes, yes.
and then they will again come up. Now they have let them go to
Yes,
review bench.
yes, yes, yes. Once it is decided, it merit, my lord.
I
And so,
am not going to review anything.
103.
All part 2 matters are disposed of.
we are obliged.
Yes, Russell Industries, tell me.
My lord, it has been filed, my lord, against the action, my lord, of the Gaon Panchayat, my lord, allowing the basic beneficiaries, my lord.
What do you want? 300A violation means your land has been taken.
My lord, beneficiaries have been selected, my lord, to construct IAY house.
Who are you?
I'm my lord, Russell T, my lord.
As to why the construction AI houses on the petitioner's garden, Romai so and so, should not be declared illegal and be quashed. And further, as to why the respondent should not be directed to stop further construction of AI houses. Yes, how are you making?
It was already been stopped, my lord, that I have to file my affidavit and it is stated, my lord.
You have stopped it?
Affidavit filed by the respondent number 4, lord.
Yes, in the Gaon Panchayat secretary have already stopped the construction of AI houses in
16/12/2014.
one, which is informed by letter dated. So you are not going to do anything. Obviously, this belongs to them. How
Lord.
can you make it?
My lord.
Heard Mr. R.S. Mishra.
My lord.
Heard Mr. Nalak. The instant writ petition has been filed by the petitioner, by the petitioner company who owns various tea states, by the petitioner company, being agreed by the actions of the respondent authorities in construction of Indra Awas Yojana bracket IAY houses in its garden, namely Romai Tea State. It appears on the court that pursuant to the issuance of notice by this court, the respondent number 4, who is the deputy respondent number 4, that is the deputy commissioner cum district collector, Now, the respondent number 4 had filed an affidavit in opposition.
Something is wrong in.
Stating inter alia that a matter relating to construction of IAY houses have been stopped by the Gaon Panchayat Secretary in the Ramai Estate area belonging to the petitioner, as was intimated to the deponent on 26/12/2014. Mr. R.S. Mishra, the learned counsel appearing on behalf of the petitioner, duly submits that the land upon which the respondent authorities are carrying out construction over the IAY houses are lands which have been settled with the respondent company upon the petitioner company on the basis of pattas being issued. And as such, the respondent authorities cannot make any construction over the said land without express permission or without acquiring the land in accordance with law. Mr. J. Hendick, the learned counsel appearing on behalf of the respondent number 4, that is the Deputy Commissioner cum District Collector, further submits that the respondent authorities have stopped raising any construction over the land of the petitioners and shall not carry out any such construction without following the due process. Taking into account the above, the instant petition therefore stands disposed of, thereby directing the respondent authorities not to raise any IAY construction houses over the land settled with the petitioner's estate without following the due process of law. Petition stands disposed.
Hundred and four.
You're gonna influct A perusal of the order dated 23/2023 impugned in the instant proceeding shows that the petitioner, along with various other registered contractors firm, were debarred from participation in all future bids of the works in the Assam PWD road wing with immediate effect for a period of 3 years. Taking into account that the period of 3 years have already expired, nothing survives the instant petition for which the petition, and as such, the petition being infructuous, is accordingly stands closed.
And 5.
To file no. That's very clear. Yes. Why haven't you filed your affidavit?
But I have already sent, Lordship, I'll file by tomorrow.
We'll take it up on Monday.
Lordship.
Monday. And for the purpose of the director, Vigilance and Anti-Corruption Assam have denied the grant of approval for prosecution of the respondent number 5.
Government has denied. Director has sought for the prosecution. Government has denied.
Why?
Well, that reason is not disclosed to us. The information is given that government has not given the sanction.
But have you registered a case?
They have registered, yes. But this is the instructions given to me.
So, no, this is only for the purpose of this is for initiation of a regular case.
Correct.
Not for sanction.
Lordship.
This was a preliminary inquiry which was done.
Yes, already preliminary has been done. Now the approval of the government has been sought for a regular inquiry. That approval has not been given by the government.
My lord, preliminary inquiry was completed by the Director of Vigilance and Anti-Corruption itself. They have submitted my application along with their preliminary report in December 2018. A copy of the letter has been officially given to us. The Chief Minister Assam on 17 January or 18 January 2019 accorded the approval, and accordingly approval for regular inquiry.
Mr. Counsel, Mr. What is your name?
Vikash Pucha.
First of all, why do you write letters to this Nipu Kolita Inspector General? I have no problem in you writing to those letters. But why do you make copies endorsed to judges?
Yes, my lord, because I have been summoned.
No, 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 no. Why do you make copies or or forward one copy to the judges who have been taking
Yes,
matters?
Let me explain.
Yes.
On 24th April, we have filed the complaint on Prime Minister's portal, and accordingly, the Government of India forwarded our grievance to Government of Assam in 2021 April itself regarding this same matter after the expiry of 90 days period, which has been fixed by the Honorable Apex Court. When after the expiry of 90 days, we filed complaint to the Prime Minister's portal.
Mr.
Sir, let me.
No, 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 no.
Sir.
Kindly listen.
Sir.
Why do you endorse copy to judges?
My lord, because I am personally appearing and pursuing this case.
No,
before
no.
this court.
First of all, you are not to send copies to judges. Remember, we only take up the matter in the court. We have no other business to receive these copies. You are a petitioner in person, therefore I'm telling you, making it very clear to you. Never send any copy to judges. They have no other business. You can't send it. You may send it to the Chief Justice. It's a different aspect of the matter. The Chief Justice can, he has also the administrative control over the High Court, but not to judges, not to puny judges. Next time you are a petitioner in person, therefore I'm telling you, never do that. These letters, you have marked it to Justice Michael Jothang Kumar, to Justice Ajit Bhattacharya, because they have taken up the matter, so
Yes.
that is why.
Yes,
You can't do that. They have no business out there. Like for today, I am taking up this matter. I may not take up the matter if the roster is not there with me. You can't send these type of documents. We are not bothered with these documents. We only take up the matter when we are in the court.
I will take care on the next time.
Next time, never do that.
Okay.
Yes. Why wouldn't you file your affidavit?
Lordship, it is ready, my lord. I have already sent.
Okay, we'll have it on Monday.
By tomorrow, I'll file.
We'll have it on Monday.
Lordship.
Mr. Dean R. Dalan, Senior Government Advocate, submits the affidavits as directed to be filed by the order dated 12/6/2023. Would be filed by tomorrow. So list the matter again on 24th of July 2023. The registry shall also enclose the affidavit so filed.
Lord, that instruction I'll take with you. Lordship.
Don't do that. Your name, you give your name in the slip. And I can list all other matters.